I'm for the respondent, my lord. Last occasion, my lordship is directed to Mr. Ghosh to appear in this matter. On yesterday, my lord.
Directed?
Mr. Ghosh to appear in this matter. Mr. Ghosh is leading me, my lord, in this matter. So I'm paying for short passover so that.
That's your other side.
Other side, Mr. Devasis Kundu, my lord.
Next Tuesday.
Next Tuesday, my lord.
Item number 2, I am for the respondents, my lord. In this,
I am for a appellant manner update by Mr. Bandyopadhyay. Lord, I am praying for a short passover.
Last time also you prayed for that, John.
The difficulty is, Mr. Bandyopadhyay is not well, my lord, but he will come. Mr. Bandyopadhyay is not well, my lord, but he will come, my lord.
my lord, last occasion, my lord, matter was also urgent, my lord, we are suffering.
My
lord, just
passover, my lord, he will be there, my lord.
Not this week. If you don't wish to do, don't mention, for this way it becomes embarrassing for us.
My lord, only
Matters are mentioned from the bottom of the list. Take it up urgently.
yesterday, my lord.
Yes, next.
Actually,
ওটা কি next Tuesday? Item number 3. তুমি একটা ফার্স্ট কল করো তো দেখি। 3.
my lord, in one matter, I am for the respond.
দেখি। যেদিন তুমি হিয়ারিং করো না সেদিন কেউকে বার করি। Yes. Second call though. Yes.
What point involved in this appeal, madam? CPF to GPF.
Where is your application?
Application, there is no application, only memo of appeal.
So what order do you want?
Was a hearing, this appeal.
You have to file an application, then for preparation of paper book and filing. Unless there is an application, what order will you pass?
What is a short point
The
involved?
short point has to be hard now. Take appropriate steps. Yeah, দ্বিতীয় কোনো কাগজই দেয়।
Was it heard on affidavits? Was it heard on affidavits?
No. Only dismiss on the ground of delay regarding petition.
Actually, you came 23 years later.
Retired on 2001. Petitioner in 2023 filed an application to refund all this amount along with interest. But due to protect, my lord, his wife, my lord, he filed this application.
File a proper application, Mr. Mukherjee, learned advocate appearing for the appellant.
Not well.
My lord, item number
My lord,
2, my lord,
Next
Mr.
item. Yes.
Item number 4, flip.
Yes, who is there? You're for the respondent.
My lord, in one matter, I am for the respondent. In another matter, I am for the applicant.
Who is your other? Yes. Which is your matter? It item
আপনার কি এদিকে এলে সুবিধে
রবীন্দ্রনাথ দাস।
আপনার এদিকে এলে কি সুবিধে এদিকে এলে সুবিধে এদিকে এলে আপনার সুবিধে বলছি এইদিকে এলে কি আপনার সুবিধে এই স্লিপটা My lord, in MAT number 693 of 2017, in this matter, I am for the appellant. And my lord, the another matter, Mr. Mojumdar is for the appellant, my lord. My lord, Mr. Mojumdar's appeal, my lord, for the interest on the gratuity.
বলে না মাথাটা
And my lord,
এত কথা বলে না ফলো করো। Yes.
my lord, the two writ petition was, my lord, disposed of by a common order, my lord. My lord, I have challenging the entire order, my lord, the file this appeal. That is the MAT number 693 of 2017. And my lord, the writ petitioner challenging, my lord, the only that the interest point of the gratuity, my lord, filed this appeal, my lord. And my lord,
Who will argue first? You will argue or he will argue?
Because
I have challenged the entire.
challenge the entire judgment of Justice Shobhrata Taluk.
Yes.
What judgment started from page 98.
All the pleadings are on record.
My lord?
All the pleadings are on record.
Yes, everything.
No, my lord, in one writ petition, my lord, there was an opportunity to file the affidavit in opposition that was filed. My lord, in another writ petition, there was no opportunity to file the affidavit in opposition, my lord. That is, my lord,
My learned friend did not say the correct fact. Lordship, my lord, in the year 2007,
Just a moment. The pleadings are not on record.
my lord, kindly, my lord, come to the paragraph page
There is only one. There was only one writ petition.
two writ petition.
Two writ
Two
petitions.
writ petition, my lord, both the matter was taken together and disposed of by a common order.
So what were the two writ petitions? Challenging what?
Challenging, my lord, the disciplinary proceedings. One writ petition, my lord, there was a 4 charge sheet in two writ petition. In one writ petition, my lord, challenging the 3 charge sheet, and in another writ petition, challenging 1 charge sheet. And which was challenged, my lord, the 1 charge sheet. In that writ petition, my lord, there was a direction to file the affidavit in opposition that was filed. And my lord, which was challenging the 3 writ petition, there was no such direction for filing the affidavit in opposition. So, my lord, no opposition was filed.
So do you want to bring on record any documents to that effect?
No, my lord, we have submitted in the stay application.
Then why you are saying so? Then there is no requirement to bring.
My lord, I am not saying so. My lord, my only submission is, my lord, then one writ petition, if it in opposition file, another no opportunity was given. That is
So
my,
that opposition is on record.
on record.
দুটো আছে নাকি? combined paper book file করলেই তো ভালো। যায়। So you could have filed a combined paper book. This way, handling over documents from 4 files, it is very difficult, no? You could have filed a combined paper book which could have served the purpose.
My lord, the judgment of the learned Hit Court, my lord, discuss each and everything. My lord, the question is this.
We are wanting to get the pleadings. You are saying in one writ petition there was no exchange of evidence. In the other writ petition, he has filed. So instead of searching from the files, we could have taken up the matter in a combined short paper book. He would have filed, we could have disposed of the matter.
It is
My lord,
his appeal,
My lord,
not my appeal.
direction of this honorable court was there, my lord.
Paper book, direction was there.
No. My lord, on the basis of the stay application, my lord, that will be hard, my lord. That direction was there.
Which is your appeal?
My appeal, my lord, is MAT number 693 of 2017.
ওই ফাইলটা দাও তাহলে।
And my lord, the CAN number is 5549. That is the stay application, my lord.
আচ্ছা এইটার 554 এর স্টে অ্যাপ্লিকেশন একটা বলছে, এটা তো লিস্টে নেই কেন?
Formal paper, stay petition.
Disposed of হয়ে গেছে?
8/12/2017 এর অর্ডারে বললো যে taking for stay will be treated as informal so far as the aforesaid application.
Yes,
Dispose of করে দিয়েছে।
My lord, there was
but application has been disposed of, saying that the papers will be, yes, place. What is the,
my lord, there was a two writ petition, my lord. One is, my lord,
you place the
WP
judgment, you place the
Okay.
judgment.
Page 98.
To take your seat, Mr. Munir, take your seat.
my lord, page 198 of the stay application, my lord.
হয়ে যাচ্ছে না?
দিয়েছেন সাহেব। এই না থাকলে তো তুমি অন্য ইয়েগুলো দেখতে।
দেখতে পারবো বাট বাকি ডকুমেন্ট
এটা তো নর্মাল। Yes, page.
Page 198, my lord, of the stay application, my lord. My lord, WP number 15925 of 2016 and with WP number 1202.
Yeah, just.
মানে page 198, মানে two writ petition 1592 of 2016 and WP number 1208 of 2009.
Hmm.
Well, in second writ petition, there was no such direction for filing the affidavit. 2016 writ petition. Well, the matter was heard on 16th of December 2016 and judgment was delivered on 5th of April 2017. My lord. Both the writ petitions have come up for analogous hearing. The first writ petition being number 1208/29, challenging the three charge sheet issued against the writ petitions, two of them dated 31st of July 2007 and one 14th of August 2007. There are three charge sheet respectively allege that the petitioner has violated the conduct rule of the
Railway
Railway Protection,
Protection Force rules টা বের করো। Yes,
that the petitioner have violated the conduct rules of the Railway Protection Force, thereby necessitating departmental proceedings under Rule 153 of the RPF Rules 1987. For the short, the RPF rules. The second writ petition being WP number 15925W of 2016 seeks withdrawal of communication of dated 20 April 2016 issued by the Security Commissioner RPF Kolkata on behalf of the Chief Security Commissioner RPF Kolkata, indicating that the stand of RPF for the non-payment of gratuity, arrear salaries and other service benefit in favor of the writ petitioner. The reasons given by the SC is that three disciplinary proceedings are pending against the petitioner as initiated in the year 2007. In the view of the pending DPs, the petitioner is only entitled to provisional pension. Mr. Achin Mojumdar, learned counsel, arguing for the writ petitioner in both WP number 1 and WP number 2 submits as follows: that the petitioner was also served with a purported charge sheet on 9th December 2011 by the Divisional Security Commissioner DSC RPF for remaining unauthorizedly absent from duty. Thereafter, by way of compliance with the order of the Honorable Single Bench of this court dated 29 July 2011, the petitioner was instructed to join his place of posting at Jamalpur, Malda Division from the Kachrapara Training Center of the RPF. The DP initiated by way of the purported charge sheet dated 9th December 2011 culminated in a finding of guilty against the petitioner by the inquiring officer EO, while the EO's order dated 7th May 2011. The petitioner was removed from service by order dated 1st June 2012 issued by the CSC. Against the order of the removal from service, the petitioner prepared an appeal before the appellate authority, being the Director General RPF. The AA was pleased to modify the order of punishment of removal by converting into an order of compulsory retirement. Mr. Mojumdar argues that after the order of the AA dated 24th May 2013, the petitioner has been running from pillar to post for his retirement benefits. In this connection, Mr. Mojumdar relies upon several representations filed by the petitioners to his higher authorities at RPF dated 13 July 2013, 3rd September 2013, 12th December 2013, 22nd December 2013, and lastly on 15th September 2015. The petitioner was informed during the above noted period spanning his representation that he is required to furnish several documents along with a declaration before the DSC. The petitioner is understood to have complied with the above mentioned requirements till he was issued the letter impugned dated 20 April 2016.
yes.
একটা কথা বল।
এখানে আমরা এখানে ইমিডিয়েট সার্ভিস টার্ভিস পড়ে আছি আপনি নোট করতে পারবেন।
আপনার কাছে আছে মাঝখানে কথাটা?
না না জানি তো সেই জন্য তো বলছি আমাদের একটা কথা বাদ চলে গেছে দেখুন টোটাল বাদ চলে গেছে
What happened?
My lord, no, my lord, actually, my lord, one page was not there in this paper. In this
Take the memo of appeal. You must be having the judgment.
yes,
Give him a copy na.
yes.
Yes.
For application in this case, as far as continuation of the disciplinary proceeding is concerned, is submits that the alleged misconduct was committed by,
Where you are reading?
my lord, page 4.
Page 3. Come to the last paragraph first. Petitioner was
The
informed.
petitioner was informed during the above noted period spanning his representation that he is required to furnish several documents along with the declaration before the DSC. The petitioner is understood to have complied with the above mentioned requirement till he was issued the letter impugned dated 20th April 2016. My lord,
Page 4 is missing.
page 4 is missing. My lord, I am placing, my lord, from the memo of the
Judge খারাপ ব্যাপার। Where is page 4? Page 4 is not there in the memo of appeal also.
Yes, ma'am.
Page 4 page.
অন্যটাতে অন্য কতটা দেখ
আপনার কাছে আছে আপনার অ্যাপিলটা
পেজ 68
মানে but
Yes, place page 4.
in Mr. Mojumdar's appeal, my lord, page 4 is there.
তাই না
Page.
বুঝছো?
Page 4, yes.
Mr. Mojumdar points out that both committed pension and gratuity are statutory benefit respectively due to the writ petitioner. Accordingly, the writ petitioner is entitled to interest on delayed payment on gratuity and committed pension. The petitioner is also entitled to his area salaries between March 2010 to 24th May 2013, the latter being the date on which he was compulsorily retired. On the factual aspect, Mr. Mojumdar submits that since the order of the DA was modified by the AA from removal to compulsory retirement, the entire period of his service up to 24th May 2013 requires to be treated as regularized. Therefore, there can be no bona fide reasons on the part of the RFF to withhold arrear salaries from March 2010 to 24th May 2013. The petitioner is also entitled to interest on the arrear salaries. Referring the appeal filed by the writ petitioner to the AA, Mr. Mojumdar submits that the petitioner was illegally treated as having been unauthorizedly absent from duties. Learned counsel for the petitioner points out that while working at Kajrapara with effect from May 2007, the petitioner was transferred prior to completing his normal tenure of 5 years. The transfer of Jamalpur Malda division put the petitioner into acute family distress since his wife, after a brain operation in the year 2006, had lost her eyesight. Since there was none to look after his wife, the petitioner was required to attend her medical condition. The learned counsel argues that the stress created by the transfer order and the loss of eyesight on his wife on the petitioner rendered him seriously ill, which required hospitalization at SSKM hospital. During his treatment, the petitioner could not attend the inquiry proceedings, and the wife of the petitioner made several representations to the DSC to keep the DP pending till her husband recovers. However, proceeding with a malified motive, the DSC DA concluded the proceedings recommending removal. However, such removal was converted to an order of compulsory retirement. Mr. Mujumdar argues on legal points by first pointing out that the DSC DA appointed an EO connected to the DP who was not competent to act as EO. Furthermore, by not granting the petitioner leave to contest the DP during the period of his treatment at his hospital, the principle of natural justice have been violated. The DP has been instituted under Rule 153 of the RPF rules and not under Rule 9 of the Service Pension Rules 1993. Mr. Mojumdar points out that the Rule 9 of the pension rule confers upon the president to withhold or withdraw the pension or gratuity only in the event of railway has suffered a pecuniary loss or retiree is found guilty of gross misconduct or negligence during the period of his service, including the service rendered upon re-employment after retirement. Mr. Mojumdar submits that in the present case, no proceeding has been instituted under Rule 9 of the pension rules. The DP against the petitioner has been instituted only under Rule 153 of the RPF rules and in view of the admitted fact that the petitioner retired with effect from 20th May 2013, there does not exist any employer-employee relationship between the railway and the writ petitioner. Accordingly, no DP can be maintained against the petitioner after the date of his compulsory retirement, since none of the provisions of Rule 9 of pension rules can be placed into the service for inquiry. In support of his noted arguments, Mr. Mojumdar relies upon the following authorities. 2003 6 SCC.
No, this order of punishment, this order of removal was passed in connection with which charge sheet?
Malat, that is the charge sheet in related to the.
Have you prepared a list of dates? There were 4 charge sheets.
4 charge sheet.
Have you prepared a list?
No,
You are
Malat, in the writ petition is also there, man.
It is for us to understand how you
Yes,
can
yes.
make it easier for us
Yes,
instead of going through the voluminous documents. Tell us the story. There were 4 charge sheets issued
charge.
against the partner.
4
Then
charge.
what are the dates thereof? What happened sequentially? This way now you will explain to us. You are reading the order, you will get the documents in the writ petition, and we will entire day we will go with you without getting the synopsis of the case. Mr. Ghosh, it is high time,
Yes,
na?
yes.
You are preparing yourself. You should prepare yourself in that fashion.
Then, Malat,
You will go on 100 pages. You will go on, and we have to listen to that. আজ নেই ঠিক মতো তবে আর করবে এরা একটু প্র্যাকটিস করছে There were 4 charge sheets.
4 charge.
What are the dates of those 4 charge sheets?
Malat, 3 charge sheet, 2007, Malat. Date is, Malat. Two is 31st of July 2007. 2 charge sheet.
কি বলবো?
আমি বসে বসে
And Malat,
কারোরই ইচ্ছে নেই
another is
হিয়ারিং এ তোমায় অ্যাসিস্ট করে কারোরই ইচ্ছে
14th of August 2007, Malat.
Mr. Ghosh, you have to prepare in this fashion.
Yes,
There are 4 charge sheets.
Then, Malat, shall I come back with the list of dates
Please prepare a chart
by giving the chart paper
uh,
page number?
so that we can come to understand that what is the issue involved.
Yes.
When can you come? Tell us. We will take it up on that.
Next week, Malat.
এরকম করা যাবে? There were 4 charge sheets.
4 charge sheet.
Now, in respect of the first 3 charge sheets were challenged by Mr. Mojumdar. Those were the charge sheets of 2007. Very good. Now, so far as the letter of 1996 by which his gratuity was withheld, That was the subject matter of another
Another
writ petition. That 96 order was passed in connection with which charge sheet? On the basis of which a removal order was passed. That removal order was converted into a compulsory retirement order.
Yes,
So he said that you give me the benefits. Did he challenge that compulsory retirement order?
No,
that was not challenged.
that was not challenged.
He,
So-
my lord,
So the compulsory retirement, he wanted the benefits appertaining to that compulsory retirement order.
compulsory retirement. Yes, my lord. That because my lord, due to the pendency of the other three charge sheet,
That
Well,
was not disbursed.
authority not withhold that gratuity amount and my lord the pension amount. According to the my lord, the rule 9 of the service rule.
But that proceeding was not initiated under Rule 9. It was under
Yes,
153.
yes, my lord. Pension rule, my lord, that is only for the disbursement of pension, not for initiation of the disciplinary proceedings.
Then
But my lord, that three charge sheet,
Hmm.
that was my lord stayed by this honorable learned honorable single bench in that writ petition, my lord.
State
Stayed. For this reason, my lord, the disciplinary proceedings was not
not
continued,
complete. Could not be completed.
could not be completed.
And the person retired.
Not person retired, my lord. Yes, my lord. That compulsory retirement.
That
Person
was in 2013. No. What was his actual date of retirement?
24th May 2013.
24th May 2013. This was the date
compulsory
of your
retired by the
actual.
Order of the appellate authority.
No. This was the compulsory retirement order. 24th May 2013. Now, this order was not given effect to since the other three charge sheets were pending,
The year 2007.
in which an interim order was passed.
They sat tight over the matter for a period of 2.5 years.
Very
Did not
good.
proceed against me.
Very good. Now, what had been the order of the court? Court said what?
In this court, Malad says that after my compulsory retirement, I will not apply before the concerned authority that you please release my arrears salary as well as my gratuity and commutation leave. It was not, my lord, released. Condition is this, that three writ petition,
That was the
2007.
1996 letter.
that writ petition is pending, so your retirement benefit will not be released.
Where is that letter? 1996 letter, which you challenged in the second writ petition,
my lord, 2024, that is page 184, my lord.
page 184. That is the letter of
Later of my lord, the Security Commission,
20th April 2016.
20th, yes, my lord.
20th April 2016.
Yes,
This
sir.
is page.
Page, my lord, 184.
হ্যাঁ। Yes, place it.
My lord, page 184, my lord, letter dated 20th April 2016.
Yes.
My lord, subject non-payment of gratuity, service certificate, etc. Reference above, it is to apprise that the Sri Robindranath Das IPF has been retired compulsorily on from 24th May 2013 at Malda Division. Accordingly, all retirement benefits had been arranged to him through associates accounts via PSB number such and such and PPO number such and such. Since three numbers of DAR cases under Rule 153 of RPF Rules 1987 are pending against him till date, and those DAR cases are not yet disposed of due to stay order of the Honorable High Court. APO 1 Malda opined that only provisional pension without communication of pension may be sanctioned. Withholding DCRG leave salary may also be retained if there is a possibility of money recoverable in terms of serial number such and such. Further, it is to inform that the retirement certificate has been issued on 31st March 2016, which has been sent to him in his home address through by post.
Hmm.
My lord, that challenging that, my lord,
He preferred the writ petition.
that second writ petition of 2016 writ petition,
Now, when was the stay order granted by the High Court?
stay order granted by the Honorable High Court, my lord, on 4th March 2010. In respect of, my lord, that three disciplinary proceedings,
Hmm.
charge sheet.
Hmm.
My lord, after issuance of charge sheet, that was challenged and stay was granted.
Very good. Now, what did the court say now?
Court say, my lord,
Now,
That-
just a moment. This compulsory retirement order, first order was removal. That removal order was dated what? Which was converted to compulsory retirement?
yes, my lord.
On 24th May 2013.
24th May 2013 was the removal order.
My lord, removal,
Compulsory
removal
retirement.
order.
No.
Removal order, my
That
lord,
is the order of the appeal.
26 June 2012.
26 June 2012 was the removal order.
Removal order of the disciplinary authority.
And what was the charge sheet for that removal?
My lord, major penalty charge sheet dated, my lord, 9th December 2011.
9 December 2011 was the charge sheet.
Charge sheet, my lord.
That was for unauthorized absence.
Unauthorized absence.
Acha.
Removal order 1st June 2012.
26 June 2012. 1st June 2012. Removal order.
Removal order, my lord, 26 June 2012. My lord, that is at page 168, my lord. In the appeal, my lord, that is stated, my lord. দেখুন একদম প্রথমেই বলেছেন
Which is the
168 is 24th May 2013.
This is the compulsory retirement order.
2012.
removal order, my lord, 1st June 2012.
That is what my lord is saying.
1st June, and appeal was filed, my lord, on that day.
1st June
1st June
2000
2012.
was the removal order. First June 2012. This is as which page? This is which page?
This is, my lord, page 168.
168.
Yes, my lord.
168 is 24th May.
168 is compulsory retirement order.
Yes, my lord. At the heading, my lord, that is stated, my lord. My lord, subject,
Where is the order of 1st of June? The removal order.
order of 1st of June, my lord. My lord, order of 1st of June, my lord, that is not in the petition.
Not there.
So very good. Now 24th, this was, now what did the court say? What did the court say?
Court says, my lord, as because, my lord, that order of compulsory retirement was passed. So as soon as the order of compulsory retirement passed, there was no such employer-employee relation, and that is marched. Other three churches, that is marched with this order, my lord. So my humble and respectful.
Now show us that finding of
Yes,
the
yes. my lord, that finding of this of the honorable single bench, my lord, that is from page 8, my lord. Page 8 of the impugned order, my lord.
Yes,
Having heard the parties, your lordship got it, my lord. Having heard the parties and considering the material placed, this court arrives at the following findings. That admittedly, with the compulsory retirement of the petitioner with effect from 20th May 2013, the relationship of employer and employee between RPF and the petitioner has ceased. This court further noticed that any disciplinary proceeding against the petitioner can only be carried forwarded for retirement only charges which fall within the domain of Rule 9 of pension rules.
just a moment. What were the 3 charge sheets earlier? Those, what were the charges?
My lord, charge sheet 1 is for, my lord, the misbehaving. And my lord, that is at
That-
page, my lord, first is, my lord, page 74.
Tell us now. Pages 74, first charge sheet.
First charge sheet.
That is dated
31st of July 2007.
31st of July 2007.
My lord.
Second charge sheet,
Second charge is on the same day, 31st of July 2007.
that is also page 74.
That is also now, that is all at page 78.
And what is the third charge sheet?
My lord, third charge sheet at dated, my lord,
Page,
page 82.
page 82.
Dated, my lord, 14th of August 2007.
14th of August 2007. So what were the charges? First charge sheet charge was,
Charge was, my lord, that is the misbehaving.
and
With-
second one,
Second one, my lord, on the similar nature. And
third.
third one, my lord, that he have, my lord, the press conference was held.
Eh.
My lord, that was admitted, my lord.
No, very good. Misbehaving, first two, and the other last charge sheet was?
That is that they have, my lord, by violating the discipline of the disciplinary force, they have, my lord, press conference was held, my lord, against the higher authorities, my lord.
Acha. So there was no allegation of monetary loss.
No.
So no model turpitude, monetary loss. Very good. Now come to the finding. Come to the finding of the court. Page, internal page 8.
8, my lord, yes.
শোনো,
My lord,
railway pension, railway service pension rules টা আনো।
my lord, relevant portion, I
Not
have come with the,
relevant. আমি কবে থেকে তো বলছি অম্লান, আগের মামলাতেও বলেছি ওই তোমরা এই বড় ইয়েটা ফাইল করা, ওটা ইনকনভিনিয়েন্ট। ওখান থেকে রেলওয়ে পেনশন রুলস এর আদার বই আছে। বলি তোমরা খেয়ালও করো
actually,
না,
my lord, that
চাইলে ওই মহাভারতটা ধরিয়ে দাও আমার। ইয়েস,
pension rule, my lord, is for disbursement of pension under the pension,
ইয়েস, প্লেস দি ফাইন্ডিং।
page 8, my lord. Having heard the parties and considering the material placed, this court arrives at the following findings. That admittedly, with the compulsory retirement of the petitioner with effect from 20th May 2013, the relationship of employer and employee between the RPF and the petitioner has ceased. This court further noticed that any DP against the petitioner can only be carried forwarded post-retirement on charges which all within the domain of Rule 9 of the pension rules. This court further noticed that the DP initiated by the RPF via the charge sheet dated 9th December 2011 culminated into an order of compulsory retirement.
9 December 2011. You said 9th March 2011. Compulsory retirement removal order.
Charge sheet that date.
Removal order, my lord, that is
Was June.
This is the charge
page,
sheet.
Removal order was on the basis of a charge sheet of 9th March 2011, you said.
yes, my lord, 9th December 2011.
আমার আর্দারটাকে ডাক, সুব্রতকে ডাক। 9 December, very good. Court, yes, please.
This court
এই
further
যে-
A in the DP, the petitioner only deserves an order of compulsory retirement for not complying with the order of transfer from Kanchanapara to Jamalpur. This court is again required to notice that the charge sheets being the subject matter of the challenge in the WP number 1 dated 31st July 2007 and 14th August 2007 purported to institute inquiries under Rule 153 of the RPF rules and not under Rule 9 of the pension rules. According to the RPF, by not invoking the latter provision could not have withheld the retirement dues on the basis of an applicable provisions.
Inapplicable.
Inapplicable provisions. This court therefore must also take notice of the several decisions replied upon by Mr. Mojumdar to the effect that with the petitioner being allowed by the allowed to be compulsory retired in 2013, any pending departmental action beyond his date of compulsory retirement not being under Rule 9 is rendered infructuous. With the retirement of the petitioner, no employer-employee relationship can be stated to be notionally alive for the purpose of preserving the departmental action.
Yeah, just one moment. Now, this finding is really relating to the two charge sheets dated 31st July 2007
Like two charge sheet, 31st July
and
2007
14th August.
and
আচ্ছা,
another is my like
Good, ঠিক
14th
আছে।
August 2000.
আচ্ছা, ঠিক
Two
আছে।
charge sheet at same date.
Yes.
This court is therefore of the view that the petitioner is eligible to receive his pending gratuity, commuted pension, arrear salaries along with his arrears and regular pension with effect from 20th May 2013. That is the date of his compulsory retirement.
Now, compulsory retirement was 24th May 24th, you said?
24th May 2013.
তাহলে it is not telling, na? 20th May it is saying.
My lord, the order of compulsory retirement, that is actually, my lord, that was order was passed 24th May 2013.
তাহলে why it is said 20th May?
My lord, that was,
Hmm.
and my lord, I have also submitted two.
Just you complete it, then you argue. So from the date of compulsory retirement, he is entitled to gratuity. Next.
However, this court must notice that in WP 1, the charge sheet being the memo number such and such dated 31st of July 2007 records the fact that on 16th of June 2007, the petitioner was charged with having spoken to his superior officer in abusive language and even held a press conference at the RPF post at Bardwan, allegedly highlighting the proposed departmental action against him. The subject matter of the said charge sheet dated 31st of July 2007, together with two other charges, were assigned in WP number 1, and the Honorable Single Bench was pleased to stay further departmental action by its order dated 4th March 2010.
Where is that order? 4th
My lord.
March. Do you have the page number?
Yes, that is at page, my lord, 2008, 208, my lord. That is the last two pages, my lord, of the stay application.
এই শোনো, এটা খোলো এটা থেকে। খুলে শুধু এটা আমাকে বের করো। আর এই অর্ডার শিট ট্যাগ করে একটা ফাইল করে রাখো এখানে। অর্ডার শিট গুলো ট্যাগ করে একটা ফাইল করে রাখো। 208.
My lord, that interim order, my lord.
Huh.
May I place that? My lord, may I complete that few?
Yes, please complete it.
However, this court must notice that the WP one of the charge sheet bring the memo number such and such dated 31st of July
Where you are
2007.
reading? Where you are reading?
My lord, paragraph F.
If you have read,
My lord, the last two
please
lines.
to stay the order by a order of stay of 4th March 2010.
Yes, ma'am.
Then G.
G. In the light of the above noted facts, although this court appreciate the stand taken by Mr. Mojumdar that the RPF could have approached this court for modifying and or vacating the interim order staying the DPs. At the same time, this court finds justification in the order impugned dated 20th April 2016 that pending a judicial look at the interim order, the retirement benefits be also kept pending. This
Just what is the finding? At the same time, this court finds justification in the order impugned that pending a judicial look at the interim order, he also kept pending. Yes, next.
H. This court cannot be unmindful of the fact that in a disciplinary force such as the RPF, the petitioner who enjoyed service from 1979 till 2007 cannot have the to ventilate his grievances at the first instance by holding a suo motu press conference, notwithstanding the state of his mind arising out of the medical condition of his spouse and himself. After the order of compulsory retirement, which has been given effect to, theoretically, at least this court must deliver the opinion that the holding of the press conference not effectively denied by the petitioner is an act deserving of an appropriate disciplinary response. Accordingly, while this court directs the respondent's RPF to release the pending retirement benefits of the petitioner and regularize his arrears and regular pension payments not later than a period of 4 weeks from the date of communication of this order, however, restrain itself from the awarding any interest in his favor, although claimed as relief in PW2, WP2, WP number 15925 of 2016 and WP number 1202 stand accordingly disposed of. The interim order dated 4th March 2010 in WP1 stand thus discharged.
Yes. Now your argument.
Yes, ma'am. So my first point is, my lord, that was the wrong observation in the impugned order that railway ought to have initiated proceeding under the pension rule. My lord, the pension rule, that is only for disbursement of the, and there is a provision in Rule 9. My lord, in case if there is
No,
any,
we didn't follow. What is your argument?
my argument, my lord, that pension rule, railway service.
No, the court observation was kindly come to internal page 9, clause D.
Yes, my lord.
This is the finding which you are challenging.
Yes. Two findings mainly, my lord.
Those are clauses.
Yes, my lord, that because as soon as he is compulsory retired, no employer-employee relationship. So as there is no scope of the railway to continue the charge sheet, the charge sheet, and which that earlier they have enjoyed the interim order. And my lord, the second argument on the
The first three charge sheets were not under Rule 9.
not under Rule 9.
So the court said that with the cessation of employer-employee relationship, those three charge sheets which were not in relation to Rule 9 shall be deemed to have become infractuous.
Yes, ma'am.
This is the finding which you are challenging.
Yes.
Yes, tell us what is your argument.
In that respect, my argument is, my lord,
You are wanting to place Rule 9.
Rule 9.
Place
My
it.
lord, Rule 9, my lord, it is only for.
Thank you.
My lord, that is not the entire, that only my lord the relevant portion. আপনার কাছে আছে? And that the book is my lord.
Yes.
What are the
My
book?
lord, my lord, that,
Statutory rule is
No, Mr. Ghosh has given us copies.
my lord, that rule 9, right of the precedents to withhold or withdraw the pension.
Where is it?
My lord, that is the first page, then the
Huh.
next page. My lord.
Next page. Starts with an explanation clause.
Yes, my lord. My lord, I am just referring rule 9 and 10, my lord.
9. Yes. Yes, please.
So, my lord, that is, there is no scope for initiation. Yes, man. The president reserved to himself the right of to withhold or withdrawing the pension or gratuity or both, either in full or in part, whether permanently or for a specified period, and or ordering recover from a pension or gratuity of the whole or part of any pecuniary loss caused to the railway. If in any departmental or judicial proceedings the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that the Union Public Service Commission on
So
shall.
what is Rule 9? Rule 9 says that it can withdraw pension
Yes, madam.
if in any departmental or judicial proceeding the pensioner is found to be guilty of grave misconduct or negligence.
Yes, madam.
So if at that stage there was no finalization of the departmental
Yes, ma'am.
proceeding,
So in my case also, my lord, that 3 charge sheet, no
no
finalization.
finalization, so you can withhold if he is found guilty. If he is found guilty, if in any departmental proceeding or judicial proceedings the pensioner is found to be guilty of grave misconduct,
Yes.
then you can withhold. In this case, there was no finding of guilt against him
Yes, ma'am.
because that was pending.
Yes, grateful, my lord. So, my lord, in my case, as because I am referring this, that is the honorable single bench, my lord, that was referred. Actually, my case is with the rule 10, my lord.
Yes, Rule 10, what you want to say?
Rule 10,
Now,
provisional
Rule 9, I
pension.
think we have understood properly.
Yes, yes.
President has the power to withdraw pension if he is found guilty of any disciplinary action, if he is found guilty of grave misconduct or negligence.
During
In
the
this
period.
case, earlier proceeding was under Rule 153 and it was not a grave misconduct.
All the 4 proceedings.
So Rule 9 application to stop pension, how do you say that becomes applicable here?
Yes, ma'am.
You want to show us Rule 10?
Rule
So
10.
show us Rule 10.
My lord, Rule 10, provisional pension where departmental or judicial proceedings may be pending.
Yes.
1A, in respect of a railway servant referred to in sub-rule 3 of Rule 9, the accounts officer shall authorize the provisional.
Refer to in sub-rule 3 of Rule 9. Where is that?
My lord, sub-rule 3 of Rule 9, that is the right side, my lord, right side column.
In the case of a railway servant,
Servant who has retired or attending the age of superannuation or otherwise, and against whom any departmental or judicial proceedings are initiated, or where departmental proceedings are continued under sub-rule 2, a provisional pension as provided in Rule 96 shall be sanctioned.
so Rule 10 will not apply in his case.
My lord, this Rule 10 is
Rule 10 is relation to a employee under Rule 9(3), any railway servant. Rule 9(3) says that in case a railway servant who has deterred on attaining superannuation
Yes, or otherwise,
and against whom
against whom
dep-
any departmental or judicial
are
proceedings are
instituted.
initiated.
Not here, it was not instituted, it was pending.
Instituted. Yes.
Instituted means prior to his return.
Prior to his retirement, in my case also, my lord, prior to
Or any departmental or judicial or where departmental proceedings are continued under sub rule 2.
sub-rule 2. My lord, sub-rule 2, may I refer that sub-rule 2, my lord, that is sub-rule 2.
এটা হয় না।
The departmental proceeding referred to in sub-rule 1.
Of Rule 9.
আরে বাবা, সবই রুল 9ই পড়া হচ্ছে এখানে। If instituted while the railway servant was in service, whether before his retirement or during his employment, shall after the final retirement of the railway servant be deemed to be proceedings under the rule and shall be continued and concluded by the authority by which they were commenced in the same manner as if the railway servant had continued in service. So, my lord, in my case, one charge sheet, first charge sheet, that was, my lord, initially compulsory retirement, thereafter appeal, removal, and thereafter in appeal, compulsory retirement. But, my lord, other 3 charge sheet, which was initiated, 2 is 31st of July 2007 and 1 is 14th of August 2007. That was reinstated by the order of this honorable court, and 3 charge sheet was pending, my lord. And, my lord, in any case, my lord, the discipline.
Mr. Ghosh, those 3 charge sheets are not charge sheets under pension rules 9(1).
My lord, that definitely, my lord, that
So
is.
if it is not a proceeding under rule 9(1), then you cannot continue with it
My lord,
after the retirement.
My lord, in that my humble and respectful submission is that, my
নিজে
lord,
ভালো করে জানে, পয়েন্টটা ভালো করে জানে।
yes, my lord. My humble and respectful submission, my lord, in this regard, my lord, the rule 9 and 10, my lord, that is in respect of the pension. My lord, there is a authority of the railway to withhold the pensionary benefit or the gratuity when, my lord, and my lord, the specifically in case of a RPF, my lord, the in RPF rule is there. According to the RPF Railway Protection Force Act and rules, my lord, the disciplinary proceedings is to be initiated, and my lord, authority was done so. My lord, that is, my lord, there is no such provision to initiate this any disciplinary proceedings under this pension rule. Pension rule, my lord, how to disbursement, how to that the pension will be disbursement, and when that may be withheld. That is the provision, my lord. And in case of a disciplinary proceedings if pending, in that case, my lord, authority can withhold. My lord, my humble and
Judges. So your first argument is, in case where a disciplinary proceeding is pending under the concerned rule,
authority has the power.
Authority has the power to withhold pension.
Pension or, my lord, any
Or
pensionary
any
benefit.
retirement. This is your one argument.
This is one.
Next argument
Next argument is, my lord, that without allowing the railway or liberty giving to the railway to complete the 3 charge sheets, my lord,
এই তো পেয়েছ, without allowing,
my lord, the virtually the honorable single bench interfered with the disciplinary proceedings. That ought not to have, my lord.
that you did not challenge, Mr. Ghosh. That interim order you did not challenge.
Interim order was not challenged.
So
But my
it
lord,
became infructuous.
particularly my lord, on this respect, at the time of argument, I was there, my lord, and two honorable Supreme Court judgment I was referred.
Hmm.
My lord, that was not, no, my lord, whisper in this judgment.
Give us two Supreme Court judgments.
Yes.
So your first argument is, admittedly there was a pending disciplinary proceeding,
Three disciplinary proceedings.
and the railways had the jurisdiction to withhold the pensionary benefits in terms of Rule 9 and 10 of the Railway Pension Rules. And second was, without allowing the authority to complete the proceeding, you should not have directed us to pay the pension.
Yes, my lord. And my lord, the third argument is, my lord, even after retirement, my lord, if disciplinary proceedings was initiated prior to the retirement of compulsory, or my lord, in that case, the authority can, my lord, the continue the disciplinary proceedings. My lord,
Even after,
my lord,
authority can continue with the proceeding.
yes, my lord. If, my lord, that was initiated prior to his retirement, maybe that is a compulsory retirement.
Hmm.
And my lord, I have also specifically stated, my lord, for a moment, your lordship kindly come only two paragraph. And my lord, page 14, my lord. Page 14 of my stay application. Paragraph 4, my lord.
Page 14, 1-4
1 4.
of your stay application.
Yeah. Paragraph 4, my lord. Paragraph 4, my lord. The appellant's petitioner state that there was no such opportunity was given to the railway to file any affidavit in opposition to the said second writ petition, being WP number 15925 of 2016. Although, according to the direction of this honorable court, the railway was filed the affidavit in opposition of the first writ petition, being number such and such. And my lord, kindly come to the next paragraph 6, my lord. Next page, paragraph 6. Paragraph 6, that the appellant petitioner states that the learned trial court is hard in law as well as in fact by non-considering the judgment passed on 17th October 2012 by the Honorable Supreme Court in a special leave petition number such and such, Union of India versus Om Prakash Yadav, and the judgment আমার একটু লাগবে না। and judgment passed by the Constitutional Bench of the Honorable Supreme Court on 6th May 2010, civil lapping number such and such, South Bengal State Transport Corporation. My lord, those two, particularly the Om Prakash judgment, is very important, my lord. I have relied before the Honorable Single Bench, but my lord, there was no such whispering in the judgment itself, my lord. And my lord, that actually the matter was hard. Hearing was completed, my lord, after near about 3 months, 15 days, my lord, the judgment was delivered. Hearing was concluded, my lord, on 16 December 2016. And my lord, the judgment was delivered on 5th of April 2017. That is, my lord, near about 3 months.
Yes. What? Please show us these two judgments.
Om Prakash. Om Prakash and
Om
South Bengal.
Prakash has been reported.
Yes, yes. Both the judgment is reported.
Please give us the citations.
Obviously, very expensive.
service satisfactory service and that the allegation made against him did not justify any reduction in the amount of pension. If the disciplinary proceeding against an employee of the government are initiated in respect of misconduct committed by him, and if he retires from service on attaining the age of superannuation before the completion of the proceeding, it is open to the state government to direct the deduction in his pension on the proof of allegation made against him.
No,
If
no,
the
there
charge-
is no, there is no dispute as regards the proposition. This Article 470 of Civil Service Regulation is similar to Rule 9, where there is a grave misconduct.
My lord, in my case, my lord, the honorable in the trial
All
court,
right, paragraph 6
in
kindly
respect of
place.
one charge sheet, my lord, that was admitted.
Eh?
In respect of one charge sheet, that allegation was also admitted and recorded in the impugned
That
order.
is why interest has been denied. That is why court has directed not
So, my lord, remaining two charge sheets was there, my lord.
remaining two is not a charge under Rule 9.
No, my
Mr.
lord.
Ghosh,
No, I have never
jene
stated that
shunei
all the charges, whatever maybe the charge sheet was issued, that is under the Railway Protection Force rules. And my lord, my humble submission is, my lord, there is no requirement to initiation of separate proceedings under the pension rules. My lord, that is only a power, my lord.
Yes, yes.
6. Grant of pension to the employees of the state government is regulated by the Civil Service Regulation, which have statutory character. Article 348A provides that the pension shall be granted subject to the condition contained in the regulation. Article 351A empowers the governor to withhold or withdraw the pension or
This
any.
is parameted here with Rule 9. This what you are reading.
Yes, my lord. Kindly see the findings of this of the Honorable Supreme Court. That is paragraph, my lord,
8.
9 and 10. My
9.
lord. 9, my lord. The High Court was not justified in quashing the show cause notice. When a show cause notice is issued to a government servant under a statutory provision calling upon him to show cause, ordinarily the government servant must place his case before the authority concerned by showing cause and must place his case before the authority concerned by showing cause, and the court should be reluctant to interfere with the notice at the stage unless the notice is shown to have been issued palpably without any authority of law. The purpose of issuing show cause notice is to afford it an opportunity of hearing to the government servant, and once cause is shown, it is open to the government to consider the matter in the light of the facts and the submission placed by the government servant, and only thereafter a final decision in the matter could be taken. Interference by the court before the stage would be premature. The High Court, in our opinion, ought not to have interfered with the show cause notice. The High Court the High Court order is not sustainable for yet another reasons. Respondent writ petitioners challenging the order of dismissal had been finally disposed of on 10th August 19. My lord, in my case also, my lord, in this case, Supreme Court observed that the show cause notice that cannot be interfered also. But in my case, my lord,
No, Supreme Court said even if you have interfered with the show cause notice, the finding of punishment was set aside.
yes, my lord.
Then
So-
Supreme Court said it ought to have gone back to the stage when where the irregularity occurred.
In my case also, my lord, that initially, my lord, the 3 charges were pending, my lord, but virtually, my lord, all the 3 charges has been quashed.
All right. Thank you, Mr. Ghosh. Yes.
And my lord, another 3 judgment. That is, my lord, 1989 AIR Supreme Court cases, page 1843. My lord, paragraph 5, 6, 7, and 25.
1989.
1989 AIR SC 1843. 5, 6, 7, 25.
Paragraph 5, 6,
7 and 25, my lord.
7 and 24.
25. Five, my lord, even before he was compulsory retired by the government orders dated 10th
Come
October
to which
19,
paragraph here?
my lord, paragraph 5.
Show us the proposition of law, na? Don't read the entire judgment.
My lord, I'm placing, my lord, 5, 6, 7 and 25 paragraph.
Yes.
Even before he was compulsory retired by the government order dated 12 October 1961, a departmental inquiry on the ground of slackness of the supervision had been initiated on 6th February 1961. Thereafter, a second departmental inquiry was ordered against the appellant on charges of overpayment to contractors and
See the
consequent,
allegation, sir. Misappropriation.
my lord, that
Jani.
first, my lord, departmental slackness of supervision.
Consequent loss to the government on eto. See the allegation, sir.
My lord, in that case also, my
As a
lord,
third inquiry,
the third
in
inquiry
advance
was
after
ordered
receipt of
against him
goods.
on the
Very
charges
good.
of
Now,
payment of
next paragraph 6, be
6.
that as it may, the appellant
The
filed a special civil application
before the High Court of Gujarat seeking issue a writ of mandamus against the state of Gujarat to direct the state to pay appellant all the outstanding salary allowances as well as the revised fee and allowances including the increment. My lord,
defended
then
this
His
action
Lordship
of
kindly come to
withholding.
the conclusion, page paragraph 25, my lord. The learned counsel for the appellant strenuously contended that after the disciplinary inquiry had been dropped on the ground that they had become infractious, the government was not right and justified in reducing the pension and gratuity on the same charges which were the subject matter of the inquiries. The argument of the learned counsel, in our opinion, does not merit consideration because the charges against the appellants were not made use for the awarding any punishment after his retirement from service, but only from the determining the quantum of appellant's pension in accordance with the rules relating to the payment of pension and gratuity. In this connection, it would be appropriate to refer the observation of the Supreme Court in the state of Uttar Pradesh versus Brahmadatta Sharma and others, which we quoted below. If the disciplinary proceedings against an employee of the government are initiated in respect of the misconduct committed by him, and if he retires from the service under attaining the age of superannuation, before the completion of the proceeding, it is open to the state government to direct deduction his pension on the proof of the allegation made against him. If the charges are not established during the disciplinary proceedings or if the disciplinary proceedings are quashed, it is not permissible to the state government to direct reduction in the pension on the same allegation. But if the disciplinary proceedings could not be completed and if the charges of serious allegation are established which may have bearing on the question of rendering efficient and satisfactory service, it would be open to the government to take proceedings against the government servant in accordance with the rules for deduction of pension and gratuity.
Tell us, Mr. Ghosh, if the 153 proceedings were allowed to be completed, can you have directed that withholding of pension? Tell us. Suppose 153 proceedings
Yes, yes.
are directed to be completed. What you could have done? You have imposed the punishments under 153, under the RPF rules. You could not have imposed a punishment under Rule 9.
Yes, my
The
my lord,
author,
my lord, kindly consider, my lord, that all the three charge sheet that
Mr.
was
Ghosh, you are not answering our argument. We are saying
no,
Brahmadatta
my
said
lord.
what? Brahmadatta said that what? That you have intercepted at the juncture, you have showcase উড়িয়ে দিয়ে, showcase you have struck down. You did not allow the disciplinary proceeding to come to a finding as he was guilty of the misconduct.
Yes.
That is why the power was exercised. You cannot step into the shoe of the disciplinary authority and say this should be the punishment.
My lord, for my
There is no dispute as regards this proposition of law. Our question to you, suppose 152, 153 proceeding was allowed to be completed. Then could you have imposed a punishment of withholding of bail?
this is, my lord, in respect of one writ petition. My lord,
Yeah.
two separate writ petition was there. My lord,
All right, thank you, Mr.
See-
Ghosh. Yes,
three
yes,
charge sheet, my lord, that was untouched, my lord.
thank you.
And my lord, this is that judgment which was referred, my lord, that is South Bengal State Transport. My lord.
South Bengal?
My lord, that is, my lord, reported in, my lord,
No, এটা you,
South Bengal State Transport Corporation versus Ashok Kumar Ghosh and other.
that court dealt with, no? Court dealt with.
That was, my lord, I also referred before the Honorable Single Bench, my lord. Ompukas and this judgment I referred, my lord, that was not considered. And my lord, my humble and respectful submission, my lord, even after retirement, the authority can continue the proceedings. That is, my lord, the receipt.
Yes, which paragraph you
My lord,
say?
paragraph 8, 10, 11, 13, 14, 15, 16, 17.
8, 10?
8, 10, 11,
হ্যাঁ,
13, 14, 15, 16, 17.
বাকি কি রইল? This is on the ground of
My lord, that even after retirement or my lord, that can be proceedings can be continued.
yes.
No, my lord. My learned friend, my lord, is harping on the point that the pending charge sheet dated 31st July 2007 and August 2007, which was pending against me, they can proceed against me on the basis of that charge sheet after my retirement from service. The lawsuit kindly see the conduct. After issuance of the charge sheet, 2.5 years they sat tight over the matter. They did not proceed. Now lawsuit kindly come to the interim order passed by this honorable court. While passing the interim order, the honorable did court, my lord, after taking cognizance of that conduct of the respondent authority, they passed the interim order. Lawsuit kindly come to the page 208. WP number 1208 W of 2009. That is last annexure of the stay application. Order passed on 4th March 2010.
Hmm. Yes.
Now logically come to page 2009, second page, 2009. Having considered the rival submission, in my opinion, the petitioner has made out a strong prima facie case. While the decision of the Honorable Supreme Court in the case of Kunsheti Satyanarayana lay down the general principle of law, the requirement of to wait for a reply before appointment to an inquiry officer has been held to the well-established principles of law in the case of V.K. Khanna, followed by this court in the above reported and unreported judgment. There is another factor which I have considered before deciding on the question of interim order. The charge sheet was issued in the year 2007. Under the normal circumstances, the writ petition would have been a belated one, having been filed about 2.5 years later. But Mr. Nojumdar submit that after issuance of the charge sheet, no step has been taken by the RPF authorities. This being the position, since RPF authorities themselves have not proceeded in this matter for such a long period of time, I am of the view that no further step ought to be taken in pursuance of the said charge sheet till the subject in controversy is final adjudicated. Then let affidavit in opposition, direction was there. Let affidavit in opposition be filed by 2 weeks reply there to successor. Matter to be listed. After the direction of this court, Malda stay order, they sat tight. The order was passed on 4th March 2010. No step was taken to vacate the interim order.
Yes.
No step was taken to proceed against me. Now at this stage, my lord, after my retirement, they came forward to proceed against me and withhold my gratuity and commutation leave on the ground that this disciplinary proceeding pending, which was started in the year 2007, after the lapse of such a period, sitting tight over the matter for 2.5 years. Now your lordship has issued that statutory rule, my lord, is very clear. Rule 9(1) of the pension rule, right to the president to withhold or withdraw pension. So there is no charge of pecuniary loss against me. There is no charge of grave misconduct. Lordship kindly see the definition of grave misconduct is there. Follow statutory rule 5, sub rule B, grave misconduct. Rule 5,
Yeah,
sub
yeah.
rule B.
Railway service pension rules.
Railway servant, that is the railway pension rules, 1993.
দাও নাকি এইটা না রেখে দেবে
The pension rule deals with the grave misconduct, and that definition is there.
rule
Rule 5. Well, rule 8, pension rule 8,
rule 8
5B. Rule 8, 5B,
হ্যাঁ
grave misconduct. Includes the communication or disclosure of any secret official code or password or any space plan, model, article, note, document or information such is mentioned in section 5 of the Official Secret Act, which was obtained while holding office under the government so as to prejudicially affect the interest of the general public or security of the state. No such allegation against me. Grave misconduct.
yes
How? My lord, they will proceed against me. And now, my lord, the pattern of decision was there. On this point, my lord, I have referred that decision, single bench also considered the cognizance of that decision. My lord, I got an opportunity, my lord, to place my case on this particular point before your lordship sitting in the single bench. And your lordship also clarified in the case of Swapn Kumar Dasgupta's case, and that judgment was upheld by the division bench. They preferred a my lord, special deputation that
he
was
knows
dismissed.
that
That was dismissed. So your lordship judgment was upheld. Swapn Kumar Dasgupta's case, both single bench and division bench, I have come. And your lordship has already, my lord, considered all the judgment. I have come, my lord, with this judgment, and
What
this
is
judgment
this
upheld by both the division bench and the honorable apex court.
can you Mr. Mojumdar, what is the citation do you know Swapn Kumar Das
This citation which referred by my lord Justice Talukdar,
ও আচ্ছা
same,
আচ্ছা
same,
আচ্ছা এখানে লেখানো
same is there.
এটা একটা দিয়েছিলাম
একটা কপি দেবেন
yes which paragraph yes
My paragraph to বলে দিই। That's why I have already
that you that internal page 15
internal page 15, yes, my lord, second paragraph. And that judgment was upheld by the division bench as well as the apex court.
Yes.
And all the judgment I have referred, my lord, I have got a copy, but I do not.
Yes.
Now, my lord,
Interest.
now, my lord, the question of interest for which I filed my appeal.
Mr. Mojumdar, interest you will not get.
Yeah, that is a statutory rule. And it is the judgment of your lordship sitting in the division bench. I'm relying upon, yes. Statutory rule. Question is this: how the writ court can take the cognizance of the writ petition, that particular paragraph, when my writ petition was not finally disposed of, that was pending, no inquiry was held, no proceeding was passed by, punishment was passed by the disciplinary authority.
There was an admission on your part.
Only
Admission.
they have quoted the paragraph. Logically,
There was an admission on your part that yes, my wife was sick. I held that conference.
yes,
Justice Talukdar observed.
but your logically
Clause F, clause H.
H. Yes. This court cannot be unmindful of the fact that in a disciplinary force such as the RPF, the petitioner who enjoyed service from 79 till 2007.
You have already got the interest. It was kept in a
My lord,
court directed the matter amount to be kept in an interest bearing scheme.
yes,
You will get that interest.
my lord, 2024 May 2013, I was compulsorily retired.
2013 you were compulsory retired.
Since that date, my lord, my gratuity and commutation leave was withheld. They have admitted. Show whether I was entitled to get the interest or not. Logically, Rule 87 of the statutory rule.
Now, first place, clause H, the finding
yes.
of the court.
This and my lord, submission. This court cannot be unmindful of the fact that in a disciplinary force such as the RPF, the petitioner who enjoyed service from 79 till 2007 cannot have the license to ventilate his grievances at the first instance by holding a suo motu press conference, notwithstanding the state of his mind arising out of the medical condition of his spouse and himself. After the order of compulsory retirement which has been given effect to, theoretically at least, this court must deliver the opinion that the holding of the press conference not effectively denied by the petitioner is an acting deserving the approbation. How this court will not take the cognizance when this petition was not finally heard and disposed of? It is a matter of August 2007 in the charge sheet, 14th August 2007. My lord, this is allegation against me. On the basis of this allegation, no inquiry proceeding was held. The disciplinary authority did not pass any final order. So how the writ court can take the cognizance and how the writ court can override the statutory rule when the rule says that I am entitled to interest on gratuity for the delayed payment. It is an admitted fact that
Show us the rules, your gratuity act. You are showing us gratuity act, payment of gratuity
Yes,
act.
yes, my lord, that was also, my lord, I am coming to your lordship judgment, sitting in the division bench. Your lordship judgment is there.
They have
Recent judgment
gone to Supreme Court.
after considering gratuity act. Sabhabhata Chakraborty and Uday Kumar. In the
They
case
have
of
gone
Muhammad
to, they
Farid
have gone to
versus
Supreme
Indra
Court,
India.
Mr. They have gone to Supreme Court.
No. 2024,
That is
Volume 4 CHN,
Justice
L 332.
Singla's judgment. Singla's judgment. Singla. Supreme
your
Court
lordship,
judgment.
after considering the gratuity act, entire gratuity act was referred by your lordship. And my lord, '23 and '24, paragraph 24. It is not my fault. So withheld my gratuity on the ground that 2007 departmental proceeding, which was initiated against you, pending. On the ground, they, my lord, withheld my gratuity and commutation leave. Although they sat tight over the matter, they did not take any step. Interim order was passed. They did not take step to vacate the interim order.
তার 24শে মে 2013 সরি 1st জুন 2013 compulsory টা 24শে মে 2013
হুম তাহলে ওর যে রিমুভালটা হলো কম্পালসারি রিটায়ারমেন্ট হলো 24শে মে 2013।
correct 13 তো কোনো স্টেপ নিল না তো
এটা তো সিম্পলিসিটার এন্টাইটেলমেন্ট গ্র্যাচুইটি নয়, এটা তো নর্মাল রিটায়ারমেন্ট। যে আমি রিটায়ার করলাম 2025-এ উইদাউট এনি রিজন, তুমি 2 বছর ধরে এখানে দিস ইজ নর্মাল রিটায়ারমেন্ট। হ্যাঁ হিস্টোরিক ল্যাপসেস আছে, কিন্তু ওর দিকে একটা absence আছে যেটা আলটিমেটলি কনফ্লিক্ট করতেই পারে। মার্চ করিয়ে দেবে ওই
সিজ করে দেয়। ওটা পোস্টটা আবার ওই
পরের
সিজটা জারি করতে
প্রসিডিংটাতে যদি আজকে ওই ক্লিন স্লেট থাকতো তাহলে তবে হ্যাঁ সুব্রতদার এই ফাইন্ডিংটা যেটা উচিত চেষ্টা করি নাই এই তোমার চেঁচাচ্ছে যে কোর্টই তো ওই জায়গায় আসতে পারে, তবে কি করে এটাকে align করতে একটা আছে বুঝছো? তো এই যে penalize করবো সবসময় তাকে হ্যাঁ নর্মাল একটা একটা বীজ আছে সেটা তো সেটা তো কোর্টের অর্ডারের ভিত্তিতে হচ্ছে। হ্যাঁ সেটা পাবে, কিন্তু he's losing the interest from আচ্ছা, what was your age when you were compulsorily retired?
Page.
He was compulsorily retired
My age was
on his compulsory retirement was in 2013.
Yes.
When was his actual date of retirement? Do you know that?
If he was not compulsory retired.
Actual date. What was his age?
Age, my lord, at the time of filing
The
petition, my lord.
writ petitioner affidavit টা কোথায়?
My lord, that is
Page
affidavit
69.
page 73. My lord,
Page
page 73,
73.
2009 January, his age was, my lord, 54.
2009 January, he was 54 years. তার মানে 6 বছর।
no, no,
9
2017, I was 62 years.
আরে আপনি লিখেছেন
Page
page
73.
73 তে দেখুন না, page 73
নয়ে
এটাই বলা আছে।
2009 54 10 11 12 13 14 15 2015-তে
Affidavit. I filed CAN number MAT 739 of 2017.
রিট পিটিশনের পেজেই লেখা আছে।
in writ petition page 73 you were 54 years in 2009.
54
So
years.
so your actual date of retirement is 2015, 60 বছর। In RPF retirement is 60 years.
60 years.
Mr. Mujumdar, this is what you are arguing. What you are arguing is if there was a simpliciter withholding of your gratuity. Suppose I was due to retire in 25, the authorities due to retire in 20, without any reason, the authority withheld for 3 years. Then I automatically become entitled to interest. But in the factual matrix, Mr. Mojumdar, interest is payable when it is a just compensation. Interest is a just compensation. It is, suppose we invest our money in a scheme. If you LIC does not give it back to me, I become entitled to statutory interest. But herein the factual metrics have to be taken into account. In the division bench judgment which we were considering, in that case, knowing though he was entitled, the authorities knowing that issue withheld it for 10 years. In this case,
Yes, in this case also there.
no, Mr. Mojumdar, in this case, had the disciplinary proceeding been completed, We do not know what would have been the punishment. Brahmadatta, that you interfered at the Shoka stage and you set aside the proceeding. Had the proceeding been allowed to continue, we do not know what would have been the end benefit.
My lord, what prevented them to continue the departmental proceeding?
You are right.
Loss of Karishi, 1 minute, 1 minute. 24th May 2013, I was compulsorily retired. After compulsorily retired from service, I made several representations. Your Lordship kindly go through my representation one by one. That is annexure P3, P4, P5. Well, from 2013 to 2016, 3 years, I continue with my representation.
It's just compensation.
Since immediately after my retirement from service, compulsory retirement from service, I made representation. First representation, your Lordship kindly come to 13 July 2013, Annexure P3, page 170. Thereafter, Annexure P4, page 170. Repeatedly I stated that you please release my pensionary benefit, gratuity, and commutation leave. Then your Lordship kindly come to page 79, that is 13/11/2013. I made several representations. All these representations were annexed in this stay application, one by one. And since 2013, May 2013 to 16, your Lordship kindly come to the last order, 184, last order, Annexure P3.
Compulsory retirement was on
24th May
May
2013.
2013.
Now, after compulsory retirement, they did not come forward with that pending charge sheet. They never stated anything. When I going on making my representation one after another since 2013 to 2016, all this time they sat tight over the matter, and suddenly they jumped and my lord say, your Lordship kindly see, 20th April 2016, they for the first time they disclosed that pending disciplinary proceeding will not allow you the gratuity and commutation leave. So what prevented them from 2013 to 2016? These 3 years, it is not the lapse on the part of the concerned authority. This lapse should be attributable to the administration. It is not a lapse on my part. So should I be deprived? When the statutory rule says that I am entitled to get the interest on
No, no,
gratuity.
Mr. Mojumdar, you cannot earn double benefit. By virtue of compulsory retirement, your earlier proceedings were declared infructuous. And you are now saying that now you pay me interest for withholding the pension.
Yes, I am not.
Both way you cannot operate,
No,
Mr.
this is
Mojumdar.
not double benefit.
Yes, because come to clause 8.
Lordship kindly see, what is the rule?
It is, Mr. Mojumdar, you are getting the benefit of this judgment on the basis of a finding that by virtue of compulsory retirement, your earlier 3 proceedings have become infructuous. This is one benefit you are getting.
Yes.
And after getting that benefit, you are saying that having made me compulsorily retired in 2013, why didn't you pay me immediately? Why they be That was a subject matter of litigation, whether after 2013 compulsory retirement, they could have disbursed the benefits in view of pendency of the proceeding. For that you came to court. For that you came to court. Court has returned a verdict in your favor. But interest is just compensation.
No, that is not correct. Your Lordship, my lords, I should be allowed, my lord, to clear.
Yes. We are discussing.
Can you see? I have been compulsorily retired by the appellate authority. Authority has passed the order. Now, my lord, on the basis of that order, my lord, I am entitled to get my pensionary benefit. This is an admitted fact. They have withheld my gratuity and commutation leave. They did not release the same. After my retirement from service, since 2013 to 2016,
Yes.
during this period, I made several representations. They did not proceed against me, they did not take any step. Now, Lordship, can you see their first conduct, what prevented them to complete the departmental proceeding, which was arising out of a charge sheet dated July 2007 and August. Why they sat tight over the matter? Why the proceeding was pending for such a period? Should I be allowed penalized?
You have made the payment, you have deposited it. In terms of the court's order, have you deposited it?
Entire payment was not made.
Uh-huh.
According to the court's order, a certain portion of the amount was
Where is the
released,
court?
but entire gratuity amount was not released.
Where is the court's order? Prima
Certain
facie
portion of the amount was released.
directing to secure amount. Is it balance of secured the amount? The reason the amount. You to deposit the entire amount of. You have not got any benefit now. You have not got any benefit.
No, I have not got any benefit.
Entire amount they have.
Withheld, my lord,
They
as regard gratuity and commutation leave, that was-
everything
that
has been
has-
deposited. Everything has been deposited in a fixed deposit.
entire amount of gratuity.
এই যে এইটা একটু ওনাকে দেখাও। আর এখানে একটা কাগজ ছিল যে ওটা ডিপোজিট করেছে, কোথায় গেল? দেখলাম তো, তোমাকে দিলাম না?
এই যে আমরা স্টে অর্ডারে যেটা ছিল না,
দেখো, খুঁজে দেখো, তোমাকে একটা ওই টাকাটা ডিপোজিট করার একটা মেমো দিয়েছিল তো।
মানে that
হ্যাঁ,
also communicated by the authority.
ইয়েস, ওইটা তুমি ওই অর্ডার শিটের সাথে ট্যাগ করে রাখ, হারিয়ে গেলে গেল। হাউ মাচ শো ইট টু হিম মিস্টার, ওইটা ওনাকে দেখো, হিজ ডিপোজিট উইচ দে মেড।
ডিডি নাম্বারটা দেখুন পেছনে, দেখুন এটা উল্টা। মানে just I want to
What you have deposited, entire amount? একটু আমায়
in
দেখাও।
compliance of the honorable court's order dated 8 December 2017 in connection with the subject purpose we have deposited the terminal benefit determined in favor of petitioner, my lord, in Calcutta main branch, West Bengal, through the State Bank India DRM office branch, Malda.
Will after compulsory retirement, do they get pension?
No, my lord, that was done, my lord, by the order of this honorable court, my lord. when
No,
the
no,
stay
that
was-
we understand. We are asking you compulsory retirement, no
No,
further
that was
pension.
done. That was done 2017, my lord.
Aha. If a person,
Retirement is not by a punishment, but he will
no,
get
after compulsory retirement, do you get pension?
pension.
My lord, that
Entire retirement benefits I will get, and I shall get the pension.
I see. So they have deposited an amount of 7 lakhs. তাই না? ওই order sheet টা দাও।
7,68,672.
But after this he will get pension, না?
Bro, আপনি এখন বলে পেনশনের পুরো টাকাটা পান না, পেনশন পান
আমি জানি না, আমি তো সেটাই
probably he
I
is
will
getting
have to
pension
take
but not the
instruction.
entire amount.
I think you get the
Extraction, I shall have to take that.
other consequential benefit. টাকাটা তো দিয়ে দিই। Interest কিন্তু দিতে একটু hesitation, self-interest। সেটা তো পাবে। আসো, the learned advocates appearing for the
Impugned order, paragraph page 9, paragraph F, my lord, there is only, my lord, that whispering regarding the one charge sheet. But my lord, regarding the other two charge sheets, no whispering in the impugned order. And my lord, due to the interim order which was passed in the year of 2010, my lord, that authority was not able to finalize the proceedings. Ultimately, the three charge sheet was not finalized, which was initiated under Rule 153. My lord, Rule 153 for the major penalty punishment, my lord.
আসো, the learned advocates appearing for the respective parties. Withdraw and pay this amount to you together with other consequential benefits, if any, that will serve the purpose. Or you can tell us. Can you tell us?
I do not know, my lord, whether he is drawing pension or other benefits. I do not know.
আচ্ছা,
cannot
তাহলে
say that.
এরকম লেখো,
My lord, 7 except this amount, all other has been disbursed.
all other,
All other has been disbursed.
so he is getting pension.
My lord, probably, my lord, not the entire amount of pension, some amount is withholding, my lord. That exactly I don't know what amount they are withholding, my lord.
So if we hold in his favor, we will say you will pay back this amount and pay and the other consequential benefits and other consequential benefits, if any.
And-
Nothing. Or you want to give us that information? Then we have to keep it as to be mentioned again.
No, what you say that if I am entitled, I shall get.
If you are entitled, you will. Yes.
Shaving.
I appear on behalf of the accident.
Shaving.
I am filing my affidavit in reply in respect of the affidavit in opposition of the respondent number 4 and 5.
We are for respondent numbers 1, 2, and 3.
See, there is
Union of India. We are filing the affidavit in opposition. Copy has already been served upon my learned friend.
Lordship, there is a short can. May I place the can and thereafter the main appeal, Lordship. Lordship, there were 12 writ petitioners, out of which 11 are the appellants in this appeal. Lordship, one of them do not wish to proceed with the matter. Lordship, that is can number 3 of 2025, Lordship. The appellant number 7 before my lords do not wish to proceed with the matter, Lordship. That is can number 3 of 2025. Lordship, paragraph number 2, Lordship.
There was a direction for filing affidavit in opposition. I am filing it for respondent number 4 and 5.
Upon hearing Mr. Guo Thakurta, learned advocate appearing
Lordship, a memorandum of understanding was signed between the Indian Meteorological Department and the ICAR, Indian Council of Agricultural Research. See, that it starts at page 39. Relevant portion is at page 41 of the stay application.
No, first tell us the story na.
Lordship, there is an agreement between the respondents that there is a scheme of Damu district agromet units being established all over India. That is in 2018. Lordship, this scheme was supposed to continue up to 2020 initially. Thereafter, Lordship, the Cabinet has taken a decision, which is at page 74, Lordship, page 73, that the scheme will be extended up to 2026. Lordship, our employment was coterminous with the scheme as well as year by year extension. Now, Lordship, from our initial appointment, we continued up to 2023. Lordship, suddenly there is a decision taken that it will be discontinued with effect from 1st of March 2024. That decision is implemented, we are terminated from our service. Lordship, we approached the learned single bench, Lordship. The learned single bench came to a finding that there is no document to show that we have continued in our service till 2024. As such, we have no right to continue in our service despite the cabinet decision taken that the scheme will continue up to 2026. The petition got dismissed. We are out of our employment. Lordship, similar matters have been taken up by different high courts all over India. All of them have been blessed with interim orders, and the persons are continuing to work in their respective posts till 2026. pursuant to the cabinet decision taken by the cabinet.
So take us to the order of the reach court which
Lordship,
you have challenged.
Lordship, kindly comes to page 101 of the. May I place the entire portion or the relevant portion, Lordship?
No, whichever you portion you want. Page
Lordship.
100 and
Lordship, it starts at page 101 of the application. Lordship may then straight away come to page 104. Paragraph 12 onwards of the impugned judgment. Page 104.
102.
104. 104. Placing paragraph 12 onwards. Having heard the counsel of for the part,
Just a moment.
having heard counsel for the parties and having carefully considered the writ petition, this court finds that the petitioners have been appointed temporarily for 1 year. It is indeed stated that appointment will be coterminous with the project. The period of appointment of each of the petitioners appears to have expired in 2020 and 21, and no documents extending their engagement beyond the period of 1 year has been disclosed. There is, however, a pleading in the writ petition that the petitioners are receiving remuneration and are working even as on date. Actually, pausing here for a moment, documents disclosed are at page 92 to 95 of the stay application, which was part of the writ petition also, that they were continuing in their services. Further, Lordship, the termination orders issued in 2024 were the subject matter of the writ petition, which was also there in the writ petition. As such, Lordship, this finding of fact is, Lordship, erroneous, Lordship.
Termination order was there.
Yes, yes.
So no, there's a period of appears to have expired. Court
Yes,
said.
that is not
That
correct.
is not a fact.
No,
You
that is
were
not-
terminated.
Yes, Lordship kindly comes to page 92 to 95 of this application. Which is
No,
also,
92 to 95 is your termination.
yes.
Very good. We will come to that.
Lordship, those were the pages, page 71 to 75 of the writ petition,
What were those?
the termination orders.
Then what is 92 to 95? That is payment of.
No, Lordship, termination, my termination shows that I continued in employment up to 2024. Those were the orders under challenge before the writ court. Lordship, the writ court comes to a finding, Lordship,
That it expired in 2021.
yes, that
Now
is not
pages 90 to 95 is what?
my termination orders, Lordship. The appellant's termination.
All right, termination. And what is pages 72 to?
No, those pages were pages 71 to 75 of the writ petition.
No, 92
means
to
those-
95 at the stay application. You will take us to that. Now
Ye-
continue with the order.
Yes. Now, Lordship, continuing from paragraph number 14. Continuation in employment beyond contractual period of service of 1 year must be deemed to have been month by month or daily basis. What is, however, relevant is the fact that the petitioner's services have been made coterminous with the scheme. 15. A fair interpretation of 1 year from appointment read with the expression coterminous with the scheme and the fact that engagement was temporary would imply that the petitioner never had any vested right of employment either under IMD or ICAR or universities which appointed them. The same is clear and explicit from the terms and conditions of appointment. A contract for a period of 1 year and continued beyond that period does not create any vested right in the petitioner to continue without any formal extension of their contracts. The expression coterminous with the scheme does not necessarily mean that the petitioners are automatically bound to be engaged by the respondents until expiry of the scheme. In backdrop of the above, the continuation of GKMA scheme under ACPRO scheme of IMD and Ministry of Work Services until 31st March 2026 cannot be understood to create any specific right on the petitioners to continue in engagement beyond the period of 1 year of expiry of their contract. Any engagement beyond the aforesaid 1 year period must be deemed to be casual. In view of the above, this court is of the view that the respondents cannot be compelled to engage the petitioners beyond 29 February 2024. There are sufficient reasons available.
What is this date? 29 February 2020.
when the decision to terminate was implemented.
But court said that it expired.
The court says that there is no document forthcoming to show that we continued after 2020 or 2021. Lordship, documents were there, part of the writ petition, part
So
of the
this is
appeal.
the termination date.
Lordship, this is the termination date. There are sufficient reasons available for discontinuation of services of the petitioners, albeit temporarily and contractual. The respondents have found that transmission of data at DAMU is collected automatically through computers. Such data analysis is done by IMD at a centralized place. In that view of the matter, this court does not find any ground to interfere with the impugned order dated 24 January 2024, issued on behalf of the Director General of Indian Meteorological Department. Accordingly, writ petition fails and is hereby
So
dismissed.
first take us to the order of 24th January 24.
Lord,
That is page.
page 89, Lordship. Page 89 of this application. Lordship, this is a communication issued by the Indian Meteorological Department to ICAR. Lordship, this is dated 24 January 2024. Lordship, the paragraph says, in continuation of IMD's letter dated letter dated 17 January 2024 regarding discontinuation of services of DAMU under Gramin Krishi Mausam Seva, it is clarified that 29 February 2024 will be the last working day for manpower, subject matter specialists, agromet observers, etc. engaged under GKMS in all DAMUs as approved by competent authority. All dues pertaining to their emoluments, etc. may be cleared before the end of the financial year 23-24. Lordship, this 24 January 2024 was a consequence of page 76, Lordship. This document speaks of the document dated 17 January 2024. Lordship, page 76 is that document. This was the first decision taken by the Government of India through Indian Meteorological Department. Page 76 of the application, Lordship, dated 17 January 2024. It is brought to your kind notice that district agromet units DAMUs will not be extended beyond the current financial year 23-24. Therefore,
This district agromet unit, this was under the India Meteorological Department.
Lordship, the scheme was under the India
What was the name of the scheme?
Lordship, the scheme is across, under which there are district agromet.
There is a scheme called
Lordship, across, then under it there is Gramin Krishi Mausam Seva.
Across.
Across.
This is the scheme.
This is the
Across.
umbrella scheme. Across. Under it there is Gramin Krishi Mausam Seva.
Excellent. Under which there is
Gramin Krishi Mausam Seva. Under that, Lordship, district
Gramin Krishi
Mausam Seva, GKMS.
Now under that
DAMU, district agromet units, in which we were appointed.
your writ petition was dismissed.
Yes.
Very good.
Now, Lordship, page 76, Lordship, I have shown, Lordship, this was the initial decision taken by the Government of India, Indian Meteorological Department, Lordship, which is at variance with the cabinet decision taken to extend the scheme up to 2026. Lordship will find the decision at page 73 of the application.
So the page 76 says that it was extended till 23-24.
Lordship, It is to be closed,
by 1st of March 2020.
Lordship. Lordship.
This decision you will find at page
Lordship,
72.
this is at variance with the cabinet decision taken to extend the scheme up to 2026, under which, Lordship, I am claiming my employment up to 2026 at least.
So you mean to say this page, this page 76?
Yes, page 76 and, Lordship, the page 89 are at variance with the cabinet.
Just a moment. 76
and page 89, Lordship, I have shown, which is in the impugned order, mentioned in the impugned order.
are at variance with the cabinet.
Yes.
Where is that cabinet?
Page 73.
The cabinet decision, that is just at
Page 73.
3 of the application. Lordship, placing the first paragraph. The Cabinet Committee on Economic Affairs, chaired by the Prime Minister Shri Narendra Modi, today gave its approval for continuation of the umbrella scheme, Atmosphere and Climate Research Modeling Observing Systems and Services, within bracket across, along with it 8 sub-schemes to the next financial cycle of 5 years, that is 2021 to 2026, at Earth Sciences Ministry of Environmental Sciences through its units, namely IMD and other mentioning are there. Lordship, the main scheme is the across, which has been granted approval by the cabinet to be extended up to 2026. Under it, Lordship, there is GKMS, and under that there is DAMUS, in which we were appointed through regular advertisement and appointment letters were issued. Ultimately, Lordship, our services have been terminated. Lordship, the read code.
Your letter of termination is at page?
Lordship, page 92 to 95, Lordship.
page 73, which you says the cabinet committee
Lordship.
approval, that's for the main umbrella project.
Lordship.
Across.
Main
not for GKMS, not for DAMU.
No, Lordship, kindly see the language, Lordship. All these sub-schemes are mentioned, Lordship. Page 73, Lordship, first paragraph. Lordship, where it says across, and thereafter the line, along with it 8 sub-schemes for the next financial year. Lordship, it is they admit that it was extended. Lordship, the decision to revoke has been taken at a lower level than the cabinet. Our contention is that that cannot be done. Lordship, there is mentioned, Lordship, along with it 8 sub-schemes for the next financial year 2021 to 2026. Now, Lordship, my termination.
Come to your termination.
Lordship,
Page 92.
92. Lordship, page 92 is one of the termination letter issued to one of the appellants. In consonance with the communication received from ICAR Atari, wide such and such dated 29 January 2024, read with clarification given by the IMD Mosam Department, dated 24.
Now, this ICAR Atari is what?
Lordship, that document is at page 101, Lordship.
Where from this ICAR 101 is the order of the court?
No, Lordship, that document is not with me, Lordship. Lordship, there are
consonance with communication received ICAR, Vide memo of 29 January 24.
Lordship, there are 3 communication. First,
let us understand. Now we are trying to understand
Yes.
your case.
Lordship, may I submit? Lordship, first is 17 January, then there is 24 January, then there is 29 January, in consequence of which these termination orders were issued to us.
17 January.
17 January is at page 76. Lordship has already seen.
17 January 2024.
Lordship, page 76, my lord has seen.
Yes.
Then there is a clarification which is dated 24 January 2024. That my lord has seen at page 89. Now, Lordship, there is possibly another third communication dated 29 January 2024, Lordship, which we are not aware of. Not part of the writ petition or the affidavit. But Lordship, this is in consequence to 17 January and 24 January. The services rendered by the subject matter specialist within bracket agromet and agromet observer in Murshidabad KVK, Jalpaiguri KVK and North Chobbish Pargona under the aegis of the university will be discontinued from 29 February 2024. This order is treated as final letter of notice for termination of services of the concerned KVK. The senior most scientist and head is hereby instructed.
So you were employed under the West Bengal University of Animal Research?
Lordship, through West Bengal University of Animal Research and Sciences.
You were inducted in Damu?
Yes, Lordship is the next page, Krishi Vigyan Kendra, Kollar. Through various agencies through which this
Show us your engagement letter first.
Lordship, the appointment letters are from page 50, Lordship. Lordship, these appointments were given following notices being floated by the respondent number 6, 7, 8 and 9. Thereafter interviews being conducted and thereafter these appointment letters were issued. Lordship,
So your only point is when the cabinet has said that it should continue till March 26,
March.
how you can terminate?
Yes.
Now what is their reply to that?
Lordship, their reply to that is, Lordship, at a secretariat level, Lordship, a decision has been taken for discontinuation of the DAMU all over India.
Page 76.
Implementation of that decision is at page 76. Implementation of the decision is at page 76. Lordship, those Lordship will find properly in affidavit in opposition as used by the respondent.
No, what is their point to that? That we have, so one aspect is that it is coterminous with the scheme. Where do we find that?
Lordship, that is from the memorandum of understanding as well as our appointment letters. Lordship, kindly see the memorandum of understanding, 12th April 2018, relevant pages, page 41, Lordship. This was the initial memorandum of understanding signed between the parties of the Government of India, which led to the process of our engagement. Lordship, clause number 3.7.
This was a memo of understanding IMD and
ICAI, dated 12th of April 2018. Lordship, clause number 3.7, page 41. IMD agrees to bear salary travel contingency allowance for the post of subject matter specialist working at KVK at scale of scientist B.
yes, coterminous.
That is such and such on contractual basis, coterminous with GKMA scheme on year-to-year extension basis. Lordship, this has led to the issuance of the employment notices by the respondent number 6, 7, 8 and 9, following which, Lordship, we were recruited. Now, Lordship, this termination order effected by the respondent authorities was given effect to all over India. Lordship,
জিনিসটা হচ্ছে contractual basis on a year-to-year extension, but quota means if I want, if the authority wants, we cannot extend after 1 year. যতদিন স্কিম থাকবে আমার এমপ্লয়মেন্ট থাকতেই হবে না, আমার এমপ্লয়মেন্ট থাকবে যতদিন স্কিম, তার আগেও it can lapse if it's on a year-to-year basis. সেটার উপর সার্ভিস
PM, we have another bench.
yes, my lord, I am.
এটা কালকে কি অবস্থা আছে? ও কালকে তো আমার রাজার সাথে গেছে, রাজার সাথে গেছে। এই কালকে কি, হ্যাঁ কালকে মিটিংটা আছে না ওইটার পরে দিয়ে লিস্ট দি ম্যাটার ফর ফার্দার কনসিডারেশন, কালকের ডেটটা দিয়ে।
Can it be a continuing matter also so that it gets a precedence?
We don't know what we have said tomorrow. It will be in the list. We shall take it up as it happens. এটাই তো
Today we are in great difficulty. A peculiar resolution has been passed by the Bar Association. I don't know what to do.
what has happened.
Happened, my lord, there is a resolution that Mr. Somnath Banerjee passed away. The members will go to attend his residence, so they may not appear. And such decision, we cannot take any decision that we cannot participate in judicial proceeding. দেখ ভালো করে resolution হয়নি ওটা। Resolution হলে contrary to Supreme Court's order. This is on my on public access system, but resolution which will be passing by the office bearers.
We are not in that part.
No, no,
You
just
tell me that you
challenge he may
prove
not. No, no, why he may not? No, how he is also there.
Both of your lordships are
Cannot
part,
say. Both.
we are
part of this association at some point of time.
Cannot say that.
no that
Still
we
special
know,
member.
but we are not been a party to the resolution.
No,
So none of us were. Mr. Basu is a party because he sits in that room. He is the architect of all resolutions.
had it been that, I will not pass this type of resolution.
Is a pre-
Now it is
the pre- is लिखिए नहीं हो, एक साइड से number 1. Yes, what happened? What happened? There.
Well, he has joined and he is to produce in terms of the previous direction. Well, only thing is,
My lord, I beg to file an affidavit regarding compliance and objection to the written instructions. Okay. Stated question.
So you paid that amount.
I has paid excess 400 rupees.
It's the audiovisual fees. It was included in the fee structure notice.
And what payment is there? Your son is attending the classes.
He is enjoying the morning session. Apparent grievance has been overcome.
Then what remains? What is the problem now?
Actually, there are. I was asked to produce him before a psychologist, but no one was interested. Finally, I approached a psychiatrist at Woodland Multi-Speciality Hospital. He was interviewed by Dr. Amarnath Malli. I have given the report in the affidavit itself.
No, no, that your report you have to produce before them after 3 weeks, no? What was the
So the direction was to produce it before to your lordship.
what?
Produced in annexation number 7, page 16.
Why overwriting? So overwriting.
Page 16.
16. Continuous page 16. Annexation 7.
13.
R7.
A original, where is the original? Why this is overwriting?
Original is with me. Doctor himself has overwritten it.
Doctor himself has overwritten.
Actually, there was a carbon below the prescription. No impression was made in the carbon. That's why he.
Regarding enhancement of fees now. Classing only. Absent at present, interacting referred to as psychometry test. That's it.
My lord, original may be required for further reviewing if necessary.
আমরা বলেছিলাম যে কেপটিন অ্যামিনস্টিল 30 বলেছিলাম স্টেপস ডিসপোজার করে দিলেই তো থেকে সেটা আর কি প্রোগ্রাম
Yes.
given you have given this copy to him.
Just now. Just.
So then Mr. Bhattacharya,
No, no,
councillor's report is.
See, I think I do not know whether it contains annexures. Does it contain annexures?
Yes, yes.
You know, my copy.
His copy does not contain annexures.
16 নম্বর দেখুন।
Watch. Yes. Yes.
He has produced that councillor's report that seems to be apparently all right. That has been annexed. We have seen the original. We thought that there were some overwriting. A original down again ফেরত দিয়ে দাও।
You know, let me have a look at it and come back. You know, just now he has handed it you. And one thing, you know, 2 more things are required.
Now you said, please consider there were 7 conditions.
Yes.
Na? You go through this, whatever is required, sort it out and finish off. He will.
Keeps it, you know, next week kindly keeps it. Subject to your lordship's any gracious convenience, anytime, my lord, apart from 6 time in professional difficulty, my lord, I am indicating.
ওইটা করে দাও ওই কবে একদিন 16 তারিখ না কবে
আমরা বসছি হচ্ছে 2রা মে বসবো 16ই মে বসবো 16ই মে না
আচ্ছা
16ই মে only one thing. Now from the principal of the school has instructed me to inform my lords that on the day when the matter was taken up by your lordships, my lord, that is on the 21st, on the 22nd, on that very night, it said, at 1:47 AM, you know, the NEFT was made for the 18,400 as indicated by my lord. You know, apparently 400 rupees extra has been paid. I do not know for what reason. First, principal also is in a dilemma. In any event, my lord,
you have returned that. You have again returned.
no.
তো ঠিক আছে ঠিক আছে
And you know, there is a breakup for the exercise books for class 9, class 10 for the 24-25 session. That is amounting to 1611. My lord, if he is to continue as a regular student, then he is obliged to make this payment. My lord, he can deduct, my lord, 400 and pay 1211.
তো he will do so.
Actually, the fee notice we have received, there is another component 400, that is audio visual fee. That I have paid.
So you can
Perhaps my friend-
send him the demand. He will
Yes.
make that.
Actually,
You
Actually,
you
we are
make
not
that,
bound to buy exercise books and all that,
Right.
but they are pressing hard
do
for
it,
it.
do it. That is you will deduct 400 from that, and that comes to 1200 something. 1200 something.
Yes.
So Mr. Chaudhary,
Just there's one instruction. With the audio visual
এদিকে resolution নেবে?
no audio visual fee.
You forget. I have
No,
received the
he will
notice.
make the payment. How much will he has to pay for the books?
Milord, let him pay 1611. If 400 extra has been paid, it will be refunded back or adjusted.
1611.
11 for this exercise books.
So give it to us. Give it.
Hey, my lord,
Pursuant to our earlier order. Pursuant to our earlier order. Comma. 3টা ডাকো আগে।
বলো তো ফাদার ফিগার আছে তো বল।
Yes,
কিন্তু ফাদার ফিগার তৈরি করেছি।
see who is there.
Lord, I am appearing for the applicant. I am led by Mr.
I
Aidan
make you
Bandyopadhyay.
appear
He is
for the
appearing online.
The alleged contender is present in court. Alleged contender is present in court.
Item number 3.
Three.
You are for whom?
I am for the alleged contender.
The chairman,
Yes.
the chairman and the secretary.
The chairman is the chairman and the secretary. Chairman is in court, is appearing.
Where is secretary? Secretary,
Is online probably.
Lord, I am appearing for the petition.
Has been get out by the persons, that's why my lord, he cannot come out. He was also in teacher's custody, but he could not manage to come.
what
There is
happened?
no violation.
Mr. Vasu, what happened?
There is no violation. I can explain before my lord. What your lordship has directed?
Well, are you calling him for counseling or not?
Yes, yes. It is turn comes. So one kindly come see your lordship's order. Kindly come to page 46 of your lordship's order. Yes, yes, he's appearing with me.
He's appearing.
Yes, Dr. Patra is here.
Yes.
Yes.
Well, kindly come to paragraph 39.
Mr. Vasu, you tell us when he will be called for counseling
Yes.
and when he will be recovered.
Only calling will not do. Probably Justice Chakraborty is immediately got it because he is in this field, champion in this field. What happened, my lord? This gentleman is geography, geography,
Bengali OBC.
male, geography, Bengali, OBC. If he call for interview, he will be entitled to have the appointment. But if I don't get the part, which is not in my hand, this is the hand of the state. It cannot be appointed. I don't know, in the school, there are requirements. In a female school, I cannot post him. And that school has to be a vacancy of OBC and geography.
Why didn't it strike you when you made submission
I,
before us?
my lord,
Just a moment. When you were repeatedly insisted upon that, my lord, there will be absolutely no problem. If this
my lord, at that time, my lord, they could not anticipate. When they started, my lord,
now it is your child.
no,
Take
well,
care.
I am here to comply your lordship's order, not to.
Exactly.
What
So
we are
don't-
saying,
Don't give us this excuse of
I cannot-
inability of
I-
vacancy.
I cannot do this.
Then,
It is not,
then we have to proceed in contempt, Mr. Vasu.
it is impossible for to comply.
Vasu, kindly consider. Our order was what? That you counsel, call him for counseling.
I will do. I will do.
Recommend. You
I will recommend. That's all.
Letters shall be issued. to
And
the
this
candidate
subsequent
within
is, my lord,
for which
I must be candid. After going through this one, either for the first time I am appearing today, I find that a review petition should have been filed
No,
only for this purpose.
that has not been done.
I advise my client.
So the question of taking a review at this stage will be an impossibility.
That if your lordship think, my lord,
No,
my lord is well aware.
Review our order because it has been affirmed by the Supreme Court. We cannot.
Case will be dismissed.
Pardon?
So this your lordship can.
Naturally,
Your lordship can review. If it appears to your lordship, my lord, this is not a contempt proceeding, this is execution proceeding.
Why your chairman
Yes,
is
yes.
becoming so adamant
No,
that unless I get a declaration from the state, I will not do it.
How can I do?
That is your problem.
I cannot. I have no power.
That is your problem. That you will
I
be
have-
doing on court's order,
I
not on
cannot-
your power.
I don't have any power.
Then you ask him to file. He's personally present. We are sending him here from to DJ. We are issuing warrant of arrest against him. Yes. Call our
Deputy Secretary.
This is audacious, Mr. Vasu.
I am.
Person-
I submit, my lord. This is not. Kindly be patient. Kindly hear me.
Yes, tell us.
What your lordship has directed? Your lordship has directed. Kindly come to page 39. 452 candidate has to be called for interview and give appointment.
Page 88.
Kindly, page
Page 88. Paragraph 39.
88.
Paragraph 39. 39. Paragraph 39 of your lordship judgment. Page 88 of the contempt application. Why should I, my lord?
You like that?
Yes. Kindly see, your lordship has directed 14052 candidate has to be called for interview and will be given appointment. Now, my lord, I am giving the chart to my lord. Yes, yes. Upon such evaluation, initially 1463 plus 533 for mismatch of marks 902 for defect OMR seat. Upon further revision and perusal of records of 902 candidates, 750 candidates were brought within the zone of consideration, and accordingly 1463 minus 750, 7131 ultimately excluded. Such exclusion is not sustainable in law, and consequently the said candidate will also be covered in the zone of consideration. Now the direction. As there are in total 14339 vacancies there, cannot be any hindrance toward inclusion of all the candidates called for PT being 14052. So this is the lordship direction. 14052 has to be appointed after counselling. Thereafter, when counselling started, it is not 1 day's job. Counselling started. And I am giving the figures to your lordship. 14052, we have called for counselling 12,482. So can you take a note of that? I will file an affidavit. Now for the timing, can you take a note? 12,482 counselling called for. Out of this, my lord, 9464 either absented, they were opted and recommended. Absent was 3018, candidate absented himself.
934.
3018, either don't absented or refused to accept the place he was allotment, was given. Am I clear to lord? So 9464 was counselling made and recommended for appointment. Now rest. Now 1482 is rest. The petitioner before my lord is in the bottom in the list. The list is there. List is there. He will be calling gradually. 1482 is left out. It will be calling gradually. When his terms come, immediately it will come within a week maybe. But he may be recommended. But he is a male geography OBC B Bengali candidate. Bengali medium. Male geography OBC B and Bengali medium. Now, my lord, I have a chart where, my lord, I can show to your lordship that these are the Bengali male vacancies are available. In geography, has to be on that subject. Other subject I cannot accommodate. I mean, that is not even the lordship's intention in the order. I have to accommodate them. And this accommodation, I cannot create. As a School Service Commission chairman, I cannot create those vacancies. Each vacancy. Kindly come to take part this chart.
Have any you mean to say you don't have any male geography OBC B vacancy?
No.
Then why did you tell us?
Yes.
That's, my lord, that is the mistake
Yes.
repeated, probably, subject to correction, my lord. Probably when they started this counselling, they realized that there is no birth.
So
And it can be easily solved. But I can submit before it can be easily solved either by review or by directing the state government to convert this post. Can be done.
Before declaration of vacancy in any institution, report is called for from various stakeholders or various sub-institution or sub-board. So before declaring verification of this vacancy, you are very much, it is within your knowledge that the vacancy is there.
Yes, this vacancy is there.
Vacancy can be declared either existing and expected.
Right.
Two type of
My
vacancy.
lord, kindly come to
It
page-
has not been stated that it is expected.
Kindly
It is
come to-
existing.
Kindly come to 93.
Okay.
That is there.
The court observed, come to page 39.
Before that, would you lordship please see page 93?
no, please come to
39.
Page para 39.
39,
page
yes, I am on
58.
39.
Court observed that as there was in total 14,333.
Can you pause here for a moment?
Yes.
This 14339 is not more than that, it is there. But Here, my lord, problem is your lordship has not segregated the vacancies. That's why the berth is not available. In other courts where there is no candidate, berth is available. But so far as this candidate, berth is not available, it can be converted. If you lordship direct the state government to convert it, it easily can be converted.
The recommendation on that vacancy that this has to be treated as this since this is the court order.
I can, but I cannot.
You have to bring the compliance before us.
Certainly,
You will.
I have already done. I have given the figure.
Mr. Basu cannot take up at this stage, even if you had been a new chairman.
No, the post is nothing.
Mr. Basu,
He is the chairman.
What is my brother submitted? At the time of declaration of vacancy, if there had been no such vacancy, question of inclusion wouldn't have arisen. Then you ought to have entered into a dialogue with the government.
I cannot make myself clear, but can you allow me to repeat?
Yes,
Can you allow me to repeat?
14,300, you were not there before us when.
No. Personally, I was not there. I was not there.
So this point, because the specific argument before us that the reservation has not been followed at the appropriate stage, we negated down that contention. It was also argued as regards OBC reservation that was negated by us. And when we came to a point, 5 affidavits were filed by the commission.
That your lordship has recorded that.
And
I have read that.
the affidavits, this new point which you are urging.
This is not new point. That cannot propped up unless the counseling starts.
That was your that, Mr. Basu, what you are saying? I am the person. I am saying there are 10 vacancies. I will call 1:10. I will call 100 candidates for the 10 post.
I have called like this. But so far as
now the distribution of vacancy, I don't understand what is the distribution of vacancy. You are saying now in course of counseling, I have found that I am not having any vacancy pertaining to that.
That particular post. Other vacancies are there. Kindly come to page 93.
Then
kindly come to page 93.
How many candidates you have recommended?
Yes.
In geography OBC B. Under in geography OBC B, have you recommended any candidate there?
Yes.
Vacancy of 44.
Well, kindly one come to page 93.
Yes.
What 93? Well, kindly come to
Yes.
subject geography,
Then medium.
then medium Bengali,
Then that OBCB.
then my lord kindly see OBCB.
Then male and female combined.
OBC B.
Then male and female.
Right side, my lord, kindly see. OBCB. No. On the nomenclature portion. Subject geography, medium Bengali, category OBCB, vacancy gender male, female, vacancy 44.
Yes. Now 44.
And now his chance is in that category 132.
Waiting list.
Can you see the bottom? 132. This is the chart I have given. That cannot be anticipated on the date the counseling started.
Oh,
44 vacancies are there.
132 to the combined list one.
Right. So far as this subject 132, this is admitted. 132 in this.
Okay, forget how many candidates belong to male OBC B geography Bengali medium.
Yes. Total 44 seat vacant. We have recommended.
Is now waiting for appointment. And how many vacancies available to you?
44 is the vacancy. 36 recommended. 6 recommended.
So this 44, how many male and how many female?
That. Because out of 44, 36 vacancy fulfilled, fill up.
So there
8 left. But if he comes within this zone of merit, 132 maybe come under 8, so he will appoint it. If it is come under 9 on the merit list, then we have a difficulty that there is no birth. Am I clear to myself? This is an execution proceedings, I know. There is no hide and seek to the court.
Yes.
For that reason, you will not call him for counsel.
I will call because gradually I am calling. It starts, my lord.
So
14,000 and odd is the counseling. So we are gradually doing it. Immediately he will be called.
You have called up to 9. You have You were
My lord, it is left out.
12,408.
1482 is left.
So
482 will call.
So within 1482, how many candidates are belonging to this group?
At that when I will call him.
Why chart is Vasu? This one is remaining to be called.
No, no.
There are more than 8% in that category.
My lord, kindly take it from me. If he is coming within under 8, he will be appointed. But if he is come on the merit list 9,
Why now it coming?
my lord, this is time constant, nothing else. This is my
Compliance of the order
delayed compliance. I have
within the
conducted-
time. Compliance of the order in letter and spirit
saying-
within the time.
Submitting, my lord, this is a delayed compliance. I am not saying that I have.
So you have not
saying-
made any application.
But this is not willful. I am taking this huge number. I am doing it. We are doing it. And now only 1482 is
Tell
left
us
out.
when you are calling him from counseling.
কবে ডাকবেন?
Tell us the date when
1482?
you will go for counseling.
কবে ডাকতে পারবেন? Tentative. Only problem is there is hue and kai in the, there is a gherao, hue and kai is going on there. That is the problem. Otherwise, my instruction is within 10-15 days, we will call him and 5 rounds হয়ে গেছে।
But can I make one submission, my lord?
Come back to me.
Within 10-15 days, we can call. If subject to my lord, this problem in the.
My lord, can I make one submission to this?
Yes.
My lord, kindly come to paragraph 42 of your lordship's judgment.
We have seen this problem.
That your lordships have given a fixed time. But now they cannot say by installment I will call. And according to his convenience, he will call.
Not possible.
No, not possible or possible. Please, Mr. Basu, I have not passed any comments. Now, my lord, it is not his option's choice to call today or not call tomorrow. Now, therefore, my lord, this is
We are wanting to solve the problem.
yes,
He
yes,
must be appointed.
yes.
That-
I want that's all exactly.
It is bread and butter.
Yes, yes.
That is the concern of yours. That is
My lord, I have nothing to do anything more. But I am saying this, if he says,
we understand your problem.
my
We
lord,
the person's sufferings which he is suffering. So
yes,
you allow us to proceed in
okay, but I will not come. All right, I leave it to your lords.
after that it is not complied, we are in contempt. We
My
are
lord,
consequent.
There is no intention of not complying your order. We are proceeding. Physically not possible. That's why little
Mr.
delay.
Basu, after so much water has flown through the Ganges, if your chairman now comes and says that, my lord, today I have become wiser, today I find there were no such vacancy, I should have told the ex-advocate general that, please, sir, don't make this submission. After so much of continuous litigation, dealing with 15,000 persons, and you are being at a stage, what affirmation come, you come and say, I am helpless, sir, what I am to do? Then what is you are an expert for? Why did you need to advise your client? Your advocate is sitting on your left hand side.
We are, my lord, we are.
Are the to heart what has been stated.
No, not
then,
at all.
Then Mr. Basu,
Don't.
Mr. Basu,
Not on that. I want these orders should be implemented. But
as a senior member of the bar, it was incumbent upon you that when you engage such senior counsel in such a litigation, such a sensitive litigation, you should have thought of this at that time. That what I am saying, and it is not an oral submission, Mr.
No, affidavit is there.
We are not tentative. When Mr. Basu, when you are submitting on the basis of an instruction of a client, we also know that Mr. Basu may also falter because heat of the moment a decision is taken.
But in writing, it is not. Yes.
We know we had been there, Mr. Basu, because you being a senior counsel, we had worked as your juniors also. You used to tell us that, will you say this thing to the court?
But I am not.
But court, when we used to appear, we used to ensure that let us put this on record so that I am not in problem.
I am here before my lord as an officer of the court to execute the order. But I want your lordships. should not be there.
Not
I
that.
am assisting your lordship's advice or cooperation to implement the order.
Actually, contempt already committed.
Delayed compliance, yes.
Eh?
Delayed compliance. Delayed compliance.
Compliance, contempt already committed. If court asks you, do it within 1 week. If 1 week, as and when
I
1
know,
week
I know.
will over,
My lord, in the
contempt committed.
226 proceeding, contempt is also execution proceeding. So, my lord, his lordship order has to be executed in 2 minutes, and only thing I already conversed before, my lord. This 14,000 and 12,000 and odd, 14,052 counseling, it takes time. Physically, logistic problem is there. We have done that. Only 1482 left out. Fifth round of the counseling completed.
What is his position within 1482? What is his
His position is I found to lordship 132.
No, no,
In
1480.
that category, OBC category.
The category, how many, this 1482 counseling will be done, you are saying within 10 days?
Yes.
So maybe within 2 days you are calling the first group. This has to be in groups, na? You will not call immediate.
Yes, it is on groups. So that.
So what is his position within 1482? Within 1482 persons, what is his position?
Today we cannot assess unless he is called and assessed. Subject wise.
So you have to say,
142 is all
you are now going to frustrate the period specified by the court.
Period, my lord. I have already said, my lord, already submitted before a lordship. Kindly condone that part.
Court fixed a timeline. Now you are trying to frustrate that timeline.
My lord, it is logistic problem is there, my lord. We cannot do it physically. I have done most what I am submitting, my lord, today.
Mr. Basu,
my lord,
we are keeping it on 16th.
Give me a minute.
No, listen to us. We are keeping it on 16th. Ask your chairman. In the meantime, his counseling.
Counseling, yes.
Counseling he will complete and he will file a report to that effect before us.
Vacancy. What can be done, but allotment?
Yes.
If he is in 9th position.
Yes.
If Barthas there on that subject.
Think over, sit at home and think over. You are facing contempt of the division bench.
Yes.
Think over.
Ask
your chairman to think over whether he wants to go to anywhere else or let him talk with the government. We are not standing in the way.
My lord knows, my lord, in every school.
No, Mr. Basu, you are trying there is a shortcutting process. It is incumbent upon the chairman, if this is the problem, not to take the advice of the advocate, to go and sit with your education minister or whoever you want, that how I will solve this problem. Kindly save me, I am in contempt.
My lord knows.
We have explained.
No,
now, Mr. Basu, whatever you want to
give me a minute's time. I know my lord is not so annoyed with me.
No, it is not a question. We are irritated.
The order. I am here not to ask execution. What I am submitting,
a chairman of a commission, if he now today after so much,
he is doing his level best.
No, this situation he has not been able to appreciate.
Yes.
This is unbelievable at this stage. After 5 affidavits, it is unbelievable, simply unbelievable.
My lord knows very well. Every school has an individual roster. My lord knows that. Point roster in every school. Every school has a 100-point roster system.
Now we cannot reopen the issue, Mr. Basu. You know very well better than us.
If there is, my lord, statutory problem, I have no power. My lord not consider that. It is, so far as my power is circumscribed by a statute, I cannot alter the roster.
No, we are at a loss to understand.
Yes.
When you have not completed the counseling also, you are apprehending tomorrow I might face that I would not be able to place him within 8. You also don't know whether there will be 8.
That, my lord, I can assure, my lord.
So you have not assured, see, you are playing safe.
No.
You are playing safe.
1482, I will complete and report to your lordship.
So you come, otherwise we are not, he has to be present before us on the returnable date and tell us what is the, if he is counseling, whatever explanation is given by you, if vacancy whether there or not, we do not understand. It is his child, he has to solve the problem. and come before us with a
Is-
report
is-
what
is
he
it
has
your,
done.
is it your lordship, my lord, if there is any statutory, my lord, prohibition, how can I overcome this? I'm asking the question to myself.
You will overcome by negotiating. You will
That I
overcome
will
by
do, but-
negotiating. It is only a question. We say it is not a serious problem.
No, no, no.
It
So
is
far,
only a
it's
problem.
cooperated.
There are remaining 500 vacancies. Any
How
100
vacancies are there?
so in any one vacancy, this can be done.
It can be converted. I say it can be converted, but
But you
conversion I
cannot,
cannot do.
no, it can be converted. You have to see that it is converted
will
if that
do
is
it.
the problem.
If your lordships can pass an
We-
observation,
No. We are not.
do.
Ashok, pursuant to the earlier order of this court, the chairman of the, what is the name of the chairman?
Siddharth.
Mr. Raut, not secretary. Oh.
বলুন
What is it?
আমি না
একটা বেঞ্চ আছে।
To you, I don't know, Dr. Patro, you are being so silent. Mr. Roy is now advising. You
No, no, he is also with me. We all
Mr.
sat
Roy,
together.
it is, you are our officers first, then you are
Certainly.
persons. Justice Moshumi Bhattacharya said as a English election.
Yes.
His Lord's hard leadership made certain observations. Thereafter, personality tested. The vacancies were declared. Panel was prepared. It stagnated at a point when an issue was raised that you have not followed the reservation. Mr. Sannal argued, Mr. Mitra argued, Mr. Bandopadhyay was opposing that. Of endeavor, at not a one juncture it was told that the vacancy, because there was no possibility to that effect. Because Mr. Roy and
Okay, my lord,
No.
I repeat, vacancies are there.
When vacancies are there, it is
Conversion is necessary.
we cannot pardon we cannot pardon your latches to this effect that I didn't know that there were only 8 vacancies in this category. A situation may arise that if I take this order from court, I will not be able to
My
comply.
lord, it should have been, my lord, so far my reading is concerned, so it should have been, your lordship should have segregated.
There,
1/4 something, segregated this category wise. Then it is, everything is solved on that date itself.
It is a selection process of
Yes,
2016.
everything is correct.
Yes.
Only segregation of the total vacancies was necessitated, nothing else.
And personally,
Segregation. My lord has said 1/4 something odd vacancies. If it is segregated on that date, this 1/4 is A, B, C, D, these categories. Everything is solved. Nothing else.
You are saying there are 8 more vacancies in this category.
If it is on after this counseling, if on that date, no, if on that,
This is the field out of 44.
if
So
on,
there are 8 vacancies.
yeah, take it lordship's time. If on that date, my lord has segregated that these vacancies are available, and you appoint them.
You will not tell us.
No, on a deliberation. So I'm not saying
You will not tell us that this is your
on
problem.
deliberation.
We have to go inside and
No, on deliberation, I say the outcome
Mr.
of the
Basu,
result is
you are a senior counsel. We request you. You please.
I sat with my client.
To solve the issue and come back to us. Otherwise,
By any role to state.
You are insisting upon us to take some.
But had I any role on the state government, I will write them. I have to pursue them. It requires our lordship's blessing and one observation so that it can be solved. Because the order is executed.
actually, Mr. Bosu, counseling is for the purpose of choice of school. Not more than that.
Nothing.
They have already selected.
Yes.
They will get appointment.
Yes.
Only for choice of school.
Yes.
It is the
Subject
purpose of counseling. So it will take more than months, and you are saying that
I've done that.
Herculean task, such and such, it order,
I have done that.
timeline cannot be made.
Timeline, my lord, I pray for condonation of that. My lord, I repeatedly say, kindly condone the time. I am delay. Can be done by me. I record my submission.
No. We shall keep it on 16.
Kindly record my submission. This is on the
No,
part
your
of this.
chairman will be present before
Yeah,
us,
certainly.
and you will come, you will call him in counseling in the meantime, and come and tell us in which you are recommending. What you want to do, what we want to do, you. Otherwise,
Kindly
we
record my submission through that so that I can pursue on that through the state government. My lord, order need not be passed. This is my problem. Kindly record that.
that is your oral
This is my submission, my lord. On duty, you are there.
Contrary to your own submission, which you have argued before
Today, my lord, kindly record my submission.
on 16.
My lord, kindly, in the meantime, I can pursue with this. If you also record my submission, your lordship not order. Can record my submission so that by
We
this I
can
can pursue
only
the step.
submission that the process of counseling is underway.
And
Considering this fact, we are posting the matter on 16th May
that will not do.
for further
That
consideration.
will not. I have whatever I have submitted, the conversion of vacancy due to dearth of vacancy birth, it cannot be accommodated. This is my submission. This is my submission. My lord is not hearing that, adjudicating that submission. I record that by this I can pursue the state government and get it converted. On the next date I say, and the order is entirely complied with.
We cannot pass any order which
need not.
may have effect of modification of our earlier order.
I am not asking for any order.
Either in respect of our operative person or in respect of time.
Have I prayed, my lord, can you pass an order? I say record my submission only. That your lordships can.
We will only say that we are keeping it on 16.
I want the handle to execute the order.
We will not indulge at the instance of an apparent contemner before us.
I have not
Your
asked.
problems are not to, it is, we are not the chairman. He ought to have been conscious, and we will not leave him. If our order is not.
But I will leave. If I find there is a contempt, I will leave the matter.
You are being very staunch, Mr. Goyal. You want that your argument should be recorded so that on the basis of that you
can pursue the state government.
You will make the situation complex.
No.
You will haul up the state government.
This is one.
Do it without our
one.
Your
lordship knows. My lord, lordship was this side and will appear for the government also. My lord knows.
Your minister, you talk with your.
Your lordship knows the situation.
No.
This one submission of mine.
At all. This is not an issue at all.
That I am saying. To pursue the state government, this my submission may be recorded. That's all.
Anyway, you are free. Yes, Mr. Bandyopadhyay, you want to say anything?
Has taken all cares of my for implementation of the order. I have nothing to say. But if he says that his submissions should be recorded, then your lordships have to go for an adjudication whether.
Mr. Bandyopadhyay, what do you say about this? That suppose eventually we are not with him. This eventuality to solve the problem. Suppose you directed that you the enlisted persons would be called for counseling. As my brother has rightly pointed out, if there are 3 vacancies, the candidate we will choose which vacancy he will go.
Madam, may I submit one thing? Let them do that part. They have heard your lordship's observation. Kindly do not record that, because that will dilute your lordship's spirit of the order, what I am submitting. Yes. Because time bound is also, if your lordship, the moment your lordship pass that order or record that, therefore your lordship will dilute that. Let them come. Your lordship is giving them time up to 16th or 17th.
We are just thinking, suppose we are aware about the order we have passed. Now today, in the eventuality, suppose out of the 500 vacancies remaining,
5,000.
Suppose, like we used to do, one SC candidate is not available. All right, we convert it into an OBC candidate. It is in the hands of the Directorate of SC, ST and OBC. Today, if it is a bottleneck condition that there are no further vacancies in that particular category, Mr.
May I submit? That would be also incorrect approach would be of the commission, because my Lord Justice Chatterjee has rightly raised the question when you have advertisement has been made and you have said so that you have evaluated how many vacancies are there. Now he cannot say so today.
No,
Justice Chatterjee, my Lord Justice Chatterjee has
that
the question which has.
yeah,
May I tell you also one thing? Thing is this: Mr. Basu's client has a very proximate relationship with the secretary and the minister. That is correct. Let him make that request. Why blessings of the court is needed?
I
If
request,
his minister and the secretary doesn't help him, then he is helpless person. Let him go and approach. Why you are asking here? And not only this, and other contempts are coming on different footing. They are very adamant, man. The problem is this: School Service Commission is very adamant.
Mr. Bandyopadhyay can help us in his other capacity.
No, I in a profession, I am professional man. I don't mix up the two identities.
Execution of an order. We also want execution.
No, I want you to. You are more powerful than me.
Ashok, pursuant to the earlier order passed by this court, Mr. Siddhartha Majumdar, the chairman, West Bengal Central School Service Commission, pursuant to the earlier order, Mr. Siddhartha Majumdar, the chairman, West Bengal Central School Service Commission, is personally present, and Mr. Amolesh Chandra Rao, the secretary of the School Service Commission, is present before, has appeared online. We have heard Mr. Basu Lanet, senior advocate, appearing for the alleged contemners. We have been informed. We have heard alleged and Mr. Bandyopadhyay, Lanet, senior advocate, appearing for the petitioner. We have been informed in course of hearing that counseling is in progress and the petitioner will be called for counseling. Counseling is in progress and the petitioner will be
Call for counseling shortly.
and the petitioner will be called for counseling shortly. In view thereof, list the matter for further consideration under list the matter for further consideration.
Can it be
on
in the other way? This order will not preclude my client to talk to the government. This order at least, so that I can some handle. I want to execute the order.
where is the preclusion?
Look, my lord knows.
Huh? Have we said
My
that
lord knows.
don't talk with anybody?
Oh, my
Yeah.
lord. Advocacy.
ভুল হয়ে যাচ্ছে।
My lord knows this is advocacy. If it is recorded, I have the handle.
Earlier days, we noticed pendency of this contempt application will not preclude the alleged contemptor in comply with the order in the meantime.
No, I am candid, my lord. If this is recorded, I get the handle to talk to them. Nothing else. Kindly think about that. I want to execute the order. Give me a handle.
Handle is always with you.
Oh.
The order has been,
Statutorily, I am bound.
SLP has been dismissed. Don't invite us to write anything which may have the effect of modification of that.
I am not asking for it. I want a handle to execute this order which is there. I have not done a single side modification of your lordship's order.
কি বলেছে? List the matter for further consideration on On 6 কবে আছে? Date কবে আছে?
16
On
May.
16th.
Well, can you, if it,
On
little
16th.
more if possible, little more if possible.
On 16th. On
Because
the
that
returnable date.
logistic problem my lord has seen in the newspaper.
On
I've
the
been here out every day.
on the returnable date. You have said 10 days. We have given you more than 15 days.
But logistic problem my lord has every
No
day
logistic.
saying,
You call this. This
I cannot do, I cannot
on
work.
the-
I am sitting somewhere else.
on the returnable date, the alleged container number 1 shall file a বলে দাও।
My lord, let us,
on the
let us report back to my,
returnable date, on the returnable
let
date,
us report back.
the alleged containers would appear before us online. Shall be present, are directed to be present before this court online.
That part also my lord not giving. But not precluding me.
Mr. Vasu, try to understand, we are dealing with 15,000 candidates. We
I have
don't
given
want
up-
any
I have-
particular
that was
line.
my lord, probably I don't consider my
You
endeavor
do that,
is to-
Mr.
my
Bon-
endeavor is
no,
to
no.
execute the order in its entirety.
You execute, you talk with your concerned officer. Talk with your.
My officer will not
it
do
is-
this. I am a
If that
creature
is
of a
not
statute.
done, you have to face the wrath of
I
the
am the
court.
creature of statute, my lord. Without the power under the statute, I cannot do anything.
We have heard
That
you,
must-
Mr. Vasu. Yes, next. Yes, next.
My lord, can he appear online if he is, my lord, otherwise?
Yes, we have said earlier occasion also, we said online. If
Mr. Basu, your client loves to come to court also. You always in the Supreme Court every day.
If he is present personally, we don't have any problem.
No, no.
We have today also, we have said on. Yes, next matter.
Item number 2.
Briefly applies.
2 হলো নাকি? আইটেম নাম্বার 2 হলো। 3 হলো। ও
এটা কি?
2টা রিভিউ সিদ্ধান্ত।
It's my application for review by non-parties. Review by non-parties.
We are not parties in the.
Proceeding. Last part.
Even
I'm not-
file করতে দিয়ে দিচ্ছি আর।
I am amongst the 233 candidates.
File your evidence.
One report we have already
filed
filed in the form of an affidavit.
Pardon?
One report in the form of an affidavit has already been filed.
Oh, already.
Though there was no direction, I had prepared it to show that the petitioners are not entitled. That affidavit is on record.
That is sufficient on your part.
My lord, I could file a complete affidavit, but I think this is enough. What I have already filed,
Can we proceed on that?
I think this is enough.
No, no, if you say we can proceed on this, we'll proceed on this.
Let us proceed. Let us proceed.
We can proceed.
But there is a report, there is an exception. I'm not.
আচ্ছা এর পরের মামলাগুলো কি আছে ছোটখাটো item number 4 contempt application not a review
4 to 8 contempt.
there are 4 contempt applications
5.
so you serve contempt these are fresh applications আসো কোর্টটাতে দাও just take your seat mister there has to be an order from us na this is the first time contempt na what you have been not been called for counseling কি হয়েছে
My name has not appeared in the list. Lordship was pleased to negate the reassessment in your Lordship's order, and therefore my name didn't appear in the list. Lordship was pleased to direct that all the candidates who have appeared in the personality test should be there in the list and may be called. Last paragraph of your Lordship's order.
so you are not coming within those 14,000 and odd
My cases I am coming, but I have not been.
oh you are within those 14,000 but no but that has never been the allegation they have called everybody
No, my lord, I have not been. I have not been.
They were not included in the final merit list,
was
which we
not
published.
in the list.
That was in August. They did not raise any grievance since August last year.
no they were not in the
After your
14,000.
lordship's after your lordship's directions, when we were directed to file the final merit list within 4 weeks, we did it. Their names were not included. If they had any grievance, they could have raised it then. Now, how are they coming in a contempt? That is difficult for me at least to understand. That
no we directed that our direction was where is our order
Paragraph.
একটু ফাইলটা দাও we take up this matter
only thing is, I think there is a rising at 3:30 because of the bar resolution. The resolution was to not to pass any order
Absence of both.
in absence of the parties, and your lordships may rise at 3:30. That is the
so you people are appearing
no 3:30 onwards. Maybe we
plus
should
330
yes
so it is 327
yes. No, I'm saying it for Mr. Mujumdar because he's being told to wait. He'll lose his 3 minutes.
এখানে কি বলেছে
Lordship
we
is-
directed to prepare and publish the final merit list and panel
Yes. Rules respective of 14052 candidates in accordance with law in the period of such and such.
so this 14052 were in the final merit list
Yes, we were not included in that merit list. Our contention is that, well, kindly read the next paragraph. Within a period of 4 weeks, the commission shall hold counseling and recommend all the 14052 candidates who appeared in the personality test. I appeared in the personality test. That
then
I have
how your name did not go within
that is
140
that is the content. That is the explanation. My probable, my lord, apprehension is that my probable apprehension is that I
your date of the personality test
yes,
you have
yes,
given
yes, I've annexed. Page 35.
you were called for personality
Yes,
test
yes. Page 35 is my 25th July 2021 is my personality test.
no this 25th
July 2021 after everything.
the করে আসুক তারপর the present contempt application has been preferred alleging violation Please করে আসুন। Then in this matter, you file a composite affidavit in opposition, dealing with Mr. We have
He has
already,
disclosed his stand as he says, but there are two grounds. One is
they have
interpretation.
not disclosed.
They have disclosed in the
What I have
report.
disclosed is
Not-
that why 233 candidates were removed
not the-
from the list.
I
In
belong
the
to that
judgment
I am
of
among
your
the 233
lordship,
Can
candidates.
anything be done? Can anything be done?
no, because they're below the cutoff. So bringing them into the ambit, that would not be correct.
No, there are remaining vacancies, na, Dr. Patro.
No, we were interviewed even at the second stage. Now I'm not.
The position is this, that your lordships, while finally disposing of the matters, your lordships had said that we are to go by the e-mark sheets. We cannot reopen the issue by looking at the OMR sheets or,
That's not your lordship's judgment.
yes, that is the judgment.
No, that's twice there
So
can
we have gone on the basis of e-mark
this
sheets.
interpretation of judgment twice not has led to this apathy.
Listen,
One more delay.
Not firstly, they left us out on the basis of interpretation of a judgment delivered by this of an interim order passed by this honorable court, wherein the commission said that we have come up with an affidavit 233 have been found to be ineligible, and then they proceed. The court has permitted these selection process to carry on without this
so
233.
why didn't you come? Were
But we
you
were-
sleeping?
Only after this not rejection we came to know.
No.
Please come to only two.
Only you see that there is a ray of hope. Now let us jump.
Not please come to only 2 pages. Not
No,
whether
no,
this order has
No,
not at all.
even rejection was in August.
Only
and
after
they
the
are coming
judgment
now.
we have please
Mr.
come.
Mujumdar, is it believable? A person for fighting from 2016 litigation.
Not we were called
Has
for
not
the
followed.
interview in 2021. Not we appeared at the interview. Now to say that we did not attain the cutoff marks is something not which does not stand by the regulations or the rules applicable vis-a-vis the procedure to be adopted by the commission. That's number one. Number two, the affidavit used by the commission before this honorable court, please have a look at 226 and 229. These are the 299.
Ultimately, it boils down to the issue of exclusion of your names from the.
Behind
So
my-
that gives you a fresh cause of action. Go and file a writ petition.
And after the division bench judgment, we can't go before the honorable single bench, and not the rules of our court.
You will say we are keeping open your
Not-
challenge.
But we could have done this not following Shivdev's principle. Shivdev's. But not the rules of our court do not permit a writ petition to be listed before a division bench for the first time.
Or if the issue has been you have replied, we take it up on 16th.
Very.
Yes, chalo, take it up.